Okay, I'm going to go ahead and call the special meeting, August 19th meeting of the Tuolumne County Board of Supervisors to order. And if you would join me in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. Welcome, members of the public. Let me go over the ground rules. Since this is a special meeting, it's not the same rules as our normal meeting. We will defer public comment until the end of the meeting, and you can do that at that time. I want to thank everybody. This is actually quite a turnout for our presentation on CEQA this morning. I would like to thank our County Counsel's Office for coordinating this, and I would like to thank Remy Moose and Manley for putting the presentation together and coming before us today. Would the clerk of the board please read item number 1?
This is a presentation and workshop on the California Environmental Quality Act, CEQA.
Okay, County Counsel.
Thank you. I would like to introduce our presenter, Jim Moose. Jim is a senior partner in the firm of Remy Moose and Manley. His practice focuses on land use, water, and environmental matters with an emphasis on issues arising under CEQA, NEPA, and the state planning and zoning laws. He represents public agencies, project proponents, consulting firms, nonprofits, and individuals. He is also the co-author of the Guide to the California Environmental Quality Act. And I could go into all of the cases that he's been a part of, but I think probably the best way to describe it is, as a CEQA practitioner, this is like having Paul McCartney do a presentation on songwriting. So I am extraordinarily excited to have him here. And when the line for selfies start up, I will be first in that line.
Okay, thank you. And one more item before I turn it over to him, and that is for the board members. Feel free to ask questions as we go through the presentation. Okay, and Jim, you're up.
Thank you. I think that's the most humbling introduction I've ever had. I was just recalling talking about Paul McCartney to a friend recently. He's coming to Sacramento. We get a new arena, and consensus was he's not what he used to be. He's lost his voice, obviously dyes his hair, but he just is addicted to being on the road. So I'm taking that as a compliment, but he and I may share some of the common signs of getting older. Anyway, it's my pleasure to be here. I've got a presentation that I'm going to try to do in about 2 hours and 45 minutes, including a break. This presentation could go all week, depending on how far down we want to drill on some of these concepts, and obviously we don't have that amount of time. A lot of these slides have been around for a long time, and overall this presentation is pretty much geared to professional planners and consultants. So a lot of it's the nuts and bolts of CEQA. So I'm going to use my discretion as I go through the slides and maybe speed through those that I think are probably going to be of less interest to the board as a decision-making body. And I want to sort of concentrate on big concepts and the role of the board as the decision-maker and not spend so much time on the minutia. I do welcome interruptions, at least from the board. I think the ground rules are that you can interrupt me, but the folks in the audience can wait till about 11:45 or so. For their questions. If you find me lapsing into incomprehensible jargon and acronyms, I apologize in advance, and that certainly is a good ground for interrupting me and say, what the heck are you saying? So with that, I'm going to start the slides, and I'm going to try to talk big picture first, and then move us through the CEQA process. My hypothesis is that the general principles of CEQA are actually pretty simple, pretty easy to grasp. It's the procedures and the nuances that have been attached to the general concepts. Now that we have 45 years of court interpretation that gets really technical and hard to follow sometimes. But the general principles are actually pretty straightforward. And so I'm going to try to communicate those at the beginning and then move into some of the more technical aspects. So this is an overview of how I intend to proceed. Going to give introduction, talk about what CEQA is, a little bit about its history, how CEQA is an expression of statutes, regulations, and court cases, and then move into the CEQA process. So I'm old enough to remember as a child being in 5th grade and having my older sister give me really colorful, flowery shirts because this was the era of psychedelic things and, the crazy 60s. Two things that came out of it were a bunch of federal and a bunch of state statutes dealing with environmental issues. So the great period of legislative activism was the late 60s, early 70s, both in Congress and California. So CEQA was enacted quickly on the heels of a federal statute called NEPA, the National Environmental Policy Act. That was enacted by Congress and signed by President Nixon in 1969. And CEQA was signed by Governor Reagan in 1970. And they're very similar. The document that's at the heart of NEPA is called an Environmental Impact Statement, or EIS. And California didn't want to have its documents confused with the federal documents, so we called our documents EIRs, Environmental Impact Report. Sometimes you'll see a combined federal and state document that can be called an EIR EIS or an EIS EIR. But the concept in CEQA and NEPA both is that if governmental agencies had before them environmental information about the consequences of proposed federal actions or proposed projects in state law, it would give them pause, perhaps. They'd look for ways to minimize impacts, and in some instances they might conclude that the environmental impacts were unacceptable. So post-World War II era, up to the time of these statutes being enacted, was a period of great infrastructure development, highways, freeway system, dams, water systems, the great backbone infrastructure of the country in California. Most of that was done before these environmental laws were passed. Notwithstanding the tremendous economic benefits of that infrastructure, people realized that there were some environmental consequences that hadn't really been accounted for during that period. And so the idea was going forward for projects of those kinds, we'd have information that would allow us to understand the consequences better and to mitigate any environmental impacts that could be diminished through conditions of approval or redesign or some downsizing or different locations, those sorts of things. So CEQA started out just as a relatively simple statute. In the early 70s, the legislature delegated authority to the agency known at that time as the Resources Agency. It's now known as the Natural Resources Agency. And it would work with the Governor's Office of Planning and Research, known as OPR, to come up with CEQA guidelines, which are really regulations. And the idea was to take the bare bones of the statute and to explain the principles embodied in them and to make them more user-friendly and to provide a recipe on how to actually comply with CEQA. And then we've had courts interpreting CEQA for 45 years. And for whatever reason, there seems to be more court activity in this particular body of law than in any other aspect of civil law that I'm familiar with. We see about 25 reported Court of Appeal cases a year. So going back to 1970, there's hundreds of them now, and I try to keep them all in my head, but the older I get, some of them kind of don't stay in there as much as they used to. And so the challenge with CEQA compliance is you can look at the statute and you can look at the guidelines and you think you know what they say, but if you're not aware of some relatively obscure Court of Appeal decision or Supreme Court decision interpreting those things, there may be some duty the courts have read into these provisions that you're unaware of. So it's easy to make mistakes. And CEQA is full of general principles, which by their very nature are somewhat vague and ambiguous. And for that reason, it invites a lot of litigation. Reasonable minds can differ over the meaning of ambiguous and vague provisions. And it's the difference of opinion that gives rise to a lot of litigation. So CEQA is very heavily litigated. So continuing with the history, a real milestone and an early milestone in the history of CEQA was a 1972 California Supreme Court decision called Friends of Mammoth. And it took the word project, which was the operative term in CEQA. If you have a project, it's subject to CEQA, and asked the question, what does that mean? And I was in junior high when this happened, but some of the people who were on the scene at that time tell me that it was pretty commonly understood between 1970 and 1972 that the word project is used in CEQA really was thought to be things like public works projects undertaken by government, big highway projects, that sort of thing. The issue in front of the California Supreme Court in this case was whether governmental approval of a private development was a project. And in the case here, with the facts were it was a conditional use permit in front of the Inyo County Board of Supervisors. It was a residential project. And the court said, your approval of that action is subject to CEQA. So that was a big deal. That kind of took everybody by surprise. There was a bit of a mini economic crisis in California. There are a lot of developers who realized that at that time there was no statute of limitations under CEQA yet. And they had had approvals between 1970 and 1972 when no one thought they had to comply with CEQA. So it led to a flurry of additional legislative activity that codified the holding of the Friends of Mammoth case, but also grandfathered in all the real estate approvals that had been done between 1970 and 1972 to sort of assuage the concerns of the developers during that time period who thought they might be vulnerable. So short statute of limitations, broad application of the law. Another thing that the court said in that case is that in terms of interpreting CEQA, the courts would interpret it broadly within the reasonable scope of the statutory language in order to protect the environment. So what that means is when the courts are looking at ambiguous or vague language and they're not sure what it means, they're going to err on the side of a pro-environment interpretation. In other words, broadly interpret it. And a primary reason for that is at the very beginning of CEQA, as is the case with a lot of legislative schemes, there's intent language. So a lot of statutes are written with flowery intent language. This is what we're trying to do, and then you get to the nuts and bolts. The intent language in CEQA is full of sort of flowery language about protecting the environment, the need to protect the environment. And the court looked at that and said, okay, given that's the legislative intent here, we're going to interpret this statute broadly. So as I look back on that, I think that decision was sort of an invitation to project opponents and environmental groups to use CEQA litigation as a way to try to protect the environment if they thought agencies weren't doing it right. And it appeared that the courts said, come on in. The door's wide open to the courthouse. And so we have a lot of litigation. And to this day, it's a routine matter for courts. They plan for it. They plan for a certain number of CEQA cases. There's judges specially assigned to it. So one thing that's different between NEPA and CEQA is that CEQA has some teeth to it. And I'll explain that in detail, but just very generally under NEPA, you do an environmental impact statement when a project's of a certain magnitude. And then the federal agencies, they have to read the EIS, think hard about what they are about to do. And this environmental impact statement may say, if you do this, there's going to be terrible consequences to the environment. And they're free to do it. They don't have to mitigate their impacts. Under NEPA, it's a look before you leap statute, but it doesn't require mitigation. Now, I hasten to add that there's all sorts of federal law that does require a lot of environmental protection that tends to be read together with NEPA that leads to mitigation and things like that. Prime examples being the Endangered Species Act, the Clean Water Act, Clean Air Act. So they have this fabric of federal law that has standards for protecting the environment. NEPA is different. It's viewed against that backdrop, but NEPA itself doesn't require you to mitigate impacts. CEQA does. So this slide is a key provision of CEQA that I would say is central to the statute and really an important concept for people to understand. And there's some terms here I want to dwell on. So agencies should not approve projects as proposed if those projects have significant effects on the environment, and emphasize the word significant. If there are feasible mitigation measures or alternatives that would substantially lessen or avoid those impacts. So to break that down again, significant effect on the environment is a central term to CEQA. It's not just any old impact on the environment. It has to be adverse. Something that's a very, very minor impact doesn't rise to the level of being significant. But once you have an adverse impact that rises to the level of being significant, then there's a duty under CEQA to try to mitigate that significant impact down to a level that is not significant anymore, if it's feasible to do so. So this is not an absolute command, it's a qualified command. You do that if it's feasible. So as you can imagine, There's a lot of litigation over whether something is or is not a significant effect, because that triggers a duty. And then there's a lot of litigation over whether mitigation measures or alternatives are or are not feasible. So speaking in crude terms, if you're an environmental activist, part of an environmental group, you may argue for a low threshold for an impact being significant because that leads to more environmental protection. And you'll argue for a narrow notion of the feasibility exception. Whereas if you're a developer or you're an advocate of property rights and you're skeptical of the heavy hand of government, you might argue for a higher threshold of a significant effect and a more elastic notion of what's feasible. And so these are sort of the battlegrounds of CEQA when people fight about it. You know, when does the duty to protect the environment kick in, and what's a feasible way to do it? Sir, did you have a question?
Yeah, how do you balance the socioeconomic impacts of the so-called mitigation, and even the mitigation could have negative or significant impacts?
Excellent question, and leads me to my next slide. This goes to what does it mean to be feasible or infeasible? So you do balance economics and social and legal and technological and other considerations against the environmental considerations. And so this balancing comes in two places. One is whether something's feasible or not. And the other is if you want to approve a project and it has significant effects still, and you've determined you're doing everything that's feasible and yet there's still significant effects, then you do something called a statement of overriding consideration. Let's see if I have a slide for it here. Maybe not yet. Close enough. So this statement of overriding considerations says, we have before us a project with significant effects on the environment. We've done everything we can to mitigate that's feasible, and yet here we still have significant unavoidable effects. However, this project is going to bring jobs, it's going to bring tax money, it's going to fill a market need, it's going to serve some social purpose. Therefore, as elected decision makers who are here to make these hard decisions, we choose knowingly to go ahead with this project, notwithstanding these adverse effects. So CEQA is not a roadblock. It erects a series of hurdles before you can approve projects. These hurdles tend to make the projects more environmentally benign because you end up doing some mitigation. It's rare that it's infeasible to mitigate to any degree. And it also forces you to sort of think through as decision makers and create a record for the public of what it is you're balancing. What are the hard trade-offs associated with the policy decision before you? And quite frequently it is economics versus environment, or economics and social versus the environment. And the legislature, in requiring this of you, is putting you almost in the same position as courts, who have to explain themselves. One reason courts can't be quite as tyrannical as some other branches of government is they have to explain what they're doing. They write their decisions out. And having to explain yourself makes it hard to be a crass tyrant, because you can imagine Joseph Stalin wouldn't be able to write something that was very persuasive other than I'm a thug and I want to do this. That's not a good reason that would be upheld in court for a local agency or for the courts themselves. So it goes to the idea that elected bodies and appointed bodies ought to articulate how they grapple with these trade-offs, and then that information goes into the political arena, and then you may be rewarded or not for how you strike the balance. So in some communities, and I'll use as an example Marin County, very affluent. They don't approve many projects. You could bring them the George Lucas Space Museum, Star Wars Museum. They don't want it. They have plenty of wealth. And so for them, the balance they would strike was we value the open space more than this new museum. And they typically get rewarded for that because their constituency agrees with it. Now, there are places in the Central Valley where they'd love to get a new jail because the unemployment's 20%, and they want the jobs. In that community, if a project like that was turned down for environmental grounds, they might be thrown out of office. So the idea is the agency decision makers explain themselves. This becomes political information, and it becomes a dialogue, part of a dialogue between the elected body and its individual members and the public. So there's an idea that this is all just good political information. So you balance the concerns, put it all in writing, and then see if the public
But
likes it.
whoever goes back and looks at what, in fact, we mitigated and whether it really worked and whether we got the result that we wanted, I can share with you examples in NEPA, for instance, where I strongly believe that we did the wrong things, and you are seeing the consequences of that today. I believe that open space is a good thing to some degree, but if you manage the open space incorrectly, you get the direct result of what's happening in our SRA lands with out-of-control wildfire because we didn't manage it carefully. So, I mean, there's consequences on both sides.
Right.
The balance isn't a foregone conclusion when you mitigate inappropriately.
Right, and the extent to which you have discretion is often a function of the particular decision you're making. So, for example, when you're writing a general plan, you have very broad discretion. There are certain minimum content requirements of general plans, like you have to have your fair share of housing zoned or planned, and you have to correlate your land use and circulation elements. But beyond that, you're in the area of broad legislative discretion. And so general plans look very different in different communities, and they reflect the value systems of the different communities. However, if you were in a different context where someone was asking for a tentative subdivision map and they were consistent with the zoning and consistent with the general plan, arguably you'd have less discretion because these folks are doing what supposedly you want them to do because you've designated property with certain uses. They're coming in for that. And so in that context, you don't have this very broad discretion. There is a property right there that you need to be cognizant of. So CEQA, one important principle of CEQA is that it takes your legal authority as it finds it. It doesn't add to your legal authority. It requires you to exercise your legal authority through the prism of the categories that CEQA creates. Is there a significant environmental effect? Is it feasible to mitigate that? But you, as the county, you have a police power that allows you to legislate in the interest of the general welfare and to protect the health and safety of the community. And so CEQA is a lens through which you exercise your police power. Now, if you were a state agency, the state of California, a Regional Water Quality Control Board, Department of Fish and Wildlife, CEQA, again, takes their statutory mission as it exists, and it wouldn't give Department of Fish and Wildlife authority over air quality, and it wouldn't give the Regional Water Quality Control Board authority over terrestrial biological resources. So CEQA just is a layer added on top of the power you have, and it requires you to think in certain categories. But it doesn't give you power you don't otherwise have. So sort of return to the basic principles of CEQA. These are things that are either in the guidelines or the courts have announced. And I find that when I talk to people who want to sort of try to interpret the law on their own and not have to consult lawyers, that if you have these principles in mind, you're likely or more likely to guess what something means in the way a court would than if you didn't have these principles in mind. So it's about informing decision makers, but it's also about informing the public. So there's two audiences CEQA has in mind. Decision-making bodies who would be informed by all this information, and then the public who has an equal right to be informed. And then there's a dialogue between the two. I've talked about the teeth of CEQA. You call them retractable teeth because of this qualification that you only need to do what's feasible. But it's a problem-solving statute. Are there environmental impacts? Yes. Are there ways to take the hard edges off those environmental impacts? Well, let's see what those are. And then they'll give you options, and those are typically called mitigation measures. Alternatives are another way to go about trying to reduce the severity of projects as they're proposed. And item three basically is that. And then number 4 here is what I've talked about briefly when I talked about the statement of overriding considerations. It's a disclosure provision, ultimately, of how the agency grapples with these trade-offs. And I'd add another one that I don't think is in the slides, and that's another purpose of CEQA is to facilitate interagency communication. In California, as I'm sure you're well aware, there's kind of a balkanization of authority. seemingly innumerable public agencies with authority over little things. And so often if you're a developer, you have to get not only a permit from the county or the city, but you've got to go to a variety of state and federal agencies to get their approvals as well. The theory of CEQA is that there is a lead agency that does the environmental document, and that environmental document can then be used by these other agencies that have a role in approving the project. And so a negative declaration or an environmental impact report should reflect input from those other agencies, and then once the lead agency completes its work, its document will live on and can be used by these other agencies. So it facilitates information to decision makers and to the public. It identifies ways to solve problems that are created by proposed projects, and it facilitates conversation amongst agencies with the theory that that's all going to be more efficient compared to a scenario where everybody had to reinvent the wheel and do their own EIRs. And it doesn't always work in practice as efficiently as we'd like, but in theory, it's a good notion that everybody talks to each other, gets out on the table what their respective needs are, and so when the document comes to the Department of Fish and Wildlife or it comes to the Regional Water Quality Control Board, they have in there the analysis they need for their particular approvals. So the EIR is the most important document under CEQA. I'll get into the difference between negative declarations and EIRs. A negative declaration is a legitimate document, but it's disfavored in the sense that it's relatively easy for someone to force you to do an EIR if you do a negative declaration, if they know how to create an administrative record that there may be a significant effect on the environment, and I'll get to that in more detail. So I mentioned earlier the Friends of Mammoth case where the court announced they were going to interpret CEQA broadly to protect the environment. In the early 90s, the legislature tried to put a check on that. By the early 90s, it was clear that if you looked at the court cases that had come down between 1970 and the early 90s, the courts were sort of reading into CEQA things that no one knew was there. They found requirements in these broad terms. And this was a source of consternation for a lot of regulated businesses because they love certainty. They want to know what the rules are so they can plan for the rules. And when there's uncertainty, it makes it difficult to plan. When am I going to be in the ground? When can I open for business? When can I get a positive cash flow? So Public Resource Code Section 21083.1 essentially says to the courts, don't make stuff up anymore. Look at the language of the statute, look at the language of the regulations, and certainly enforce and apply those, but don't impose new requirements that are not evident in those provisions. And so this was intended to sort of limit the creativity and activism, frankly, of the courts. And it's had that effect to a small degree so far. It's the nature of the legal system that sometimes these statutes take a long time to bubble up to the highest levels of the judiciary. Just last year, the California Supreme Court for the first time cited this section. So, maybe its influence is beginning to be felt. Okay, now I'm going to get into a little bit of the nuts and bolts and just how the law functions. This is kind of a refresher of high school civics or college political science. In our form of government, the legislature makes the laws. The legislature can delegate to administrative agencies the ability to write regulations. The regulations have to flow from quasi-legislative authority delegated to the agencies from the legislature, and those regulations need to operate within the parameters set by statutes. They have to be consistent with the statutes. They can't contradict the statutes. So in the hierarchy, the legislature is above the administrative agencies who write regulations. And if a regulation conflicts with the statute, a court would set it aside. And the courts interpret both the statutes and the regulations. And so what's happened over the years is there's been a seemingly innumerable number of different fact situations that have arisen where courts are asked to apply these general principles of CEQA, and they apply them to certain facts, and they tease out a new rule based on the application of general principles to those facts. And to that extent, the court's function in interpreting CEQA is almost like common law. So if people know the history of England and Great Britain, going back hundreds of years, when Parliament wasn't writing very many laws, judges just made stuff up. But then they'd set precedents, and then later judges would follow those. And they would always apply the precedents to new fact situations, and then the law would grow and grow, because as you had more and more fact situations, you tease out more and more nuances. And so you get this huge body of law that started out as just someone in the 12th century making something up. The thing about CEQA is that it's a set of statutes, and it shouldn't invite courts to make things up. But because the principles are so general, it's almost inevitable that the courts find themselves behaving almost like common law judges. So examples of these general principles: what is feasible? What is reasonable? These are terms that come up. Reasonable minds can differ, and you apply those concepts to different fact situations. They draw different rules. So it's kind of an interesting phenomenon of having this particular statute give rise to so many court-made rules, even though the courts are supposed to merely apply statutes. When the legislature writes statutes that are very vague, that seems to be a consequence that the courts are going to find lots of different ways to apply them. So the guidelines, they've been around a long time. They used to be more broad in their interpretation of the statutes than they have been in the last 2 or 3 decades. And the difference is there's now an agency in the state called the Office of Administrative Law, which looks very carefully at proposed regulations to see whether they go beyond what's in a statute. And so OAL will look to see what is the source of authority for the agency. Have they been given broad delegation, or are they merely just writing regulations to try to apply statutes? And where they haven't been given broad legislative authority, like, say, the Air Resources Board has under the Global Warming Solutions Act of 2006, also known as AB 32, they're going to be skeptical about regulations sticking their neck out too much. There's a notion that the guidelines should be updated every 2 years. This was put in statute maybe 8 or 10 years ago, or maybe longer than that, now that I think about it. The idea was that the guidelines are easier to read. There's publications like this orange book here that have the statutes and the guidelines in them. Statutes are hard to read. The guidelines are a little more plain English. But if the guidelines are out of date, you might miss some new statutory requirement. So if you're reading the 1999 guidelines in the year 2000, the legislature added some new notice requirement, and it's not in the guidelines, you might miss it. So the idea is the guidelines would be updated every couple of years so they'd stay current. It hasn't really happened because every time the guidelines are updated, it's controversial. You can't make everybody happy. So if you're the governor and you're thinking, do I want to do guidelines and antagonize somebody because I can't make everybody happy, it's not that attractive a proposition to do it. Why do something where you're only going to make somebody mad, even if you make other people happy? So I talked a little bit about the division of labor between agencies. So there's the lead agency, which you think of as the one that does all the work. They do the document. Then there's a responsible agency, and there can be multiple responsible agencies. And those are agencies that have some sort of permitting authority over a project. The reason counties and cities tend to be the lead agency most times are twofold. One is the state agencies don't like to be lead agencies. They just don't like it. And over the last 45 years, they've been able to dodge it pretty well. But the other reason is their piece of the pie is usually pretty narrow, because if you're the State Department of Fish and Wildlife, you're just looking at biological resources. If you're the Regional Water Quality Control Board, you're just looking at water quality. But if you're the county or the city with a broad police power, you're looking at everything. So you have the ability to worry about traffic, air pollution, water quality, everything, because that all goes to the general welfare, the health and safety of the community. And since you have the ability to touch on all these issues, your authority is greater over the project than these other typically state agencies that just have a small slice. So part of the definition of lead agency is you have the biggest piece of the project to approve. Therefore, it's logical for you to do most of the work. Then it's incumbent on you to reach out to the responsible agencies, seek their input. What do you need, Regional Board, to issue waste discharge requirements? What do you need, Department of Fish and Wildlife, to issue a stream bed alteration agreement? And in theory, you will take their requests, and your document, prepared by your staff and consultants, will give them what they need. Now, the other category here of state agencies is trustee agencies. Now, these are agencies that don't necessarily have approval authority over a project, but they have an interest in the project because the resources that could be affected by them, by the project, are something that they have some sort of supervisory role over. The most important and common example of this is the Department of Fish and Wildlife. They do have permitting authority in many instances. They issue what are called streambed alteration agreements. They issue incidental take permits under the California Endangered Species Act. But even where they don't have that authority, under California law, they are deemed to be trustees of all wildlife in California. So if your project affects wildlife, even if the project doesn't need a permit from DFW, they're concerned about it and they can comment on your environmental document in kind of a watchdog role. And then there's something I won't dwell on much. Certified regulatory process is an abbreviated CEQA process that some state agencies qualify for if they have an environmental mission, a mission that's mainly to protect the environment. Doesn't apply at the local level, so I'll skip over that. And they have federal agencies that have a role in CEQA, but they don't have any official duties under CEQA for the simple reason that the California legislature has no authority over federal agencies and can't tell them what to do. So the legislature can tell the Department of Fish and Wildlife what to do as a responsible agency or trustee agency. They can tell you what to do as a county. They can't tell the Forest Service what to do. Only Congress can do that. Unless Congress tells the Forest Service, you've got to do what the state tells you to do. Federal agencies often interact and interface with state and local agencies, but they can't be told what to do under CEQA. So they will give you input. There are many instances in which you need to notice them, particularly with EIRs, but they don't have any official duties under CEQA. So now when I talk about the process of preparing environmental documents, I'm sure you're familiar with the two main kinds of documents. There are negative declarations, of which a variant is a mitigated negative declaration, and environmental impact reports. In most places, negative declarations are done in-house by agency planning departments or community development departments. But environmental impact reports are often farmed out to the industry of environmental consultants who have teams of specialized scientists, which you won't commonly find on a county staff. Most counties don't have a biologist on staff. They don't have a traffic engineer. They don't have a hydrologist on staff. These EIRs are big projects to do, so they're often farmed out. But they're prepared under the direction of the lead agency, and ultimately they have to reflect the values and beliefs of the lead agency. Within agencies, there's a division of labor, and this is particularly the case at the local government level. It's not so much the case at the state agency level where they have department heads rather than elected bodies. But crudely, there's staff, and then there's the decision-making body. And, of course, you're the decision-making body. The staff does the environmental work, serves it up to you, and you use that environmental work as part of your decision-making process. Under state law, there's a lot of flexibility on how to seek input from applicants. It is permissible for an applicant to actually prepare a full EIR and submit it to a county and ask the county to use that document. And the county could do that if the county found that document to be objective and fair and it actually reflected the independent judgment of the county. Now, of course, they could change the document if they thought it read too much like a sales brochure at some points. But it's possible to let the applicant have that much input. Most jurisdictions don't do it that way. There's some concern that if the applicant controls the consulting firm may not be as objective or as tough on the applicant as it should be. So the most common arrangement is for the county or city to contract with the environmental consulting firm and have the loyalty of the environmental consulting firm and its duty of loyalty lie with the agency, and then you ask the applicant to pay for it. So the applicant pays for the work, and the county or city controls it. That's the most common approach. I'll skip over that. Now, you'll see a theme in the court cases about the importance of public participation, and you even see the word transparency beginning to appear in case law. That term wasn't so popular back in the 70s and 80s, but it's pretty common now. And the idea is government in the sunshine. It's like the Brown Act. Let public input be maximized so that there's a dialogue between the government and the citizenry. And not only does that keep the citizenry informed, it should improve the quality of decision making, because although there are some individuals whose ideas are a little bit crazy, obviously, you've seen those, I'm sure, a lot of times people give you very, very good input. And so your decisions probably will ultimately be better for all this public input and certainly for all the agency input. And if you're going to err on the side of caution when you're confronting some provision of CEQA and you're not sure what it means, if you err on the side of more public input, you're more likely to be upheld by a judge, because they put a high premium on that. Okay, now I'm going to get into some of the nuts and bolts. This slide is just going to give you an overview of where I'm going to go for a while. These are complex topics, but just a real brief primer before I get into the details of the process. You can think of CEQA as a series of filters, where at the beginning, almost anything you are contemplating doing as a governmental agency would be things you might think about as being potentially subject to CEQA. And you go through a series of questions and analyses, and then what comes out the other end requiring a full EIR is only a small percentage of the universe of things that go into the funnel at the beginning. So there's a series of off-ramps, if you will, whereby benign or beneficial activities fall to the wayside, because CEQA was only concerned with adverse effects on the environment, or activities that simply have nothing to do with the environment. They'll fall to the wayside. So you have, very crudely, the question, is something a project? That's a term of art. I'll explain what it means. So that's an initial question. Are you looking at a project? If yes, then you ask another question. What are you thinking about doing with this project? Are you thinking about approving it? If you are contemplating the approval of a project, then you're probably subject to CEQA unless there's an off-ramp. Now, there's a series of off-ramps the legislature's created. They've just outright exempted certain things from CEQA, things that ostensibly would meet the definition of project, but for policy reasons, they've just exempted them out. A good example was going back to the 1980s, when Governor Deukmejian was in charge. California built a lot of prisons. A lot of those prisons were exempt from CEQA. If they hadn't had those exemptions, they would have been projects. They're big construction projects, but the legislature wanted to build a lot of prisons back then, and so they just exempted them from CEQA so they get built faster. The 1984 Olympics in Los Angeles were exempt from CEQA, for the obvious reason that if they'd been subject to CEQA, it would have been 1988 before you could have held the 1984 Olympics. So the legislature has broad authority to exempt whatever it wants. It could be crass. It could seem to reward people with the best lobbyist. In recent years, NFL stadiums and NBA arenas have been the favored objects of special breaks for CEQA. Refineries aren't given the same love as sports arenas. The more common version of a statutory exemption these days is not you're out of CEQA, but a special process with a few shortcuts. Maybe the litigation goes faster. But the general principle is the legislature created CEQA. They can change it anytime they want. They can make exceptions to it. It's not in the Constitution. They can repeal it. So they can exempt really horrible projects that they want. Then there are exemptions created by the CEQA guidelines. And these are supposed to be activities that really are small potatoes. And these exemptions are called categorical exemptions. These are little projects that it's not worth the time and money to put them through CEQA. So small structures, rebuilding a building, repairing things. And I'll get into some of the details. Those are things that are exempt from CEQA by regulation. Those are not absolutes. I'll explain that later. There are exceptions to the use of categorical exemptions. Then there's a catch-all exemption, where if you have a project that doesn't feel like it's impacting enough to justify CEQA compliance, but there's no categorical exemption right in point, no statutory exemption right in point, there's this catch-all that says if there's no possibility that the activity would have a significant effect on the environment, you're subject to CEQA. So that's there where there's nothing on point, but you kind of know deep down it's ridiculous to do CEQA for this thing. It's just too small. So that's there. Now, if none of those off-ramps are available to you and you're still going to approve a project, then you have to go into an initial study to decide whether a mitigation, a negative declaration or a mitigated negative declaration is a permissible option, or whether you have to do the full EIR. And so what comes out with is full EIRs are typically the larger projects with greater levels of impacts, and also the things that are most controversial. Because if you do a negative declaration and there's a lot of opposition, depending on what gets into the administrative record, you can be required to do an EIR. So now I'm going to break all that down into more detail. So here's the definition of project. And remember, this is a key central concept of CEQA. If you have a project, then you may have to do CEQA. So the first thing is there's got to be some foreseeable environmental impact from this proposed activity. Will it have a direct effect on the environment? You're going to build a road. Well, there's the direct effect. Even in the absence of a direct effect, is there a reasonably foreseeable indirect effect? And what that means is there could be environmental impacts, but they may be one or two steps or more removed on a causal chain. Early in the history of CEQA, there was litigation over whether things like general plan amendments or zone changes or annexations were projects, because they were several steps removed from moving dirt with a shovel. And the courts very early said, if the foreseeable consequence of one of these legislative type approvals is to set in motion a chain of events that will culminate in changes in the physical environment, that puts you in CEQA. So that's an example of an indirect effect. And there's a notion of reasonable foreseeability there. And that concept comes out of tort law. So it has to have either this direct physical effect or a reasonably foreseeable indirect effect, and it needs to be one of these three categories of things. And crudely, Category A is actions undertaken by the government. So this would be legislative actions, the adoption of a general plan, the amendment of a general plan, update of a general plan, public works projects, if you're going to build a new water treatment or sewage treatment plant or new roads. But it also comes up sometimes in the context of private development projects where someone seeks a general plan amendment or a rezone. They want to change the rules for that piece of land as part of their project. That puts that part of their project in Category A. So undertaken by the agency or involving legislative action, that's Category A. Category B, essentially activities subsidized by government. There are some sorts of projects, often like low-income housing projects, that can't really pencil in the marketplace without some sort of governmental assistance. So if you're called upon to put money into something in order to make it work, that can trigger CEQA. And then Category C here, these are things you permit without any legislative action. So a conditional use permit, tentative subdivision map, a variance. These are local activities that come under Category C. Crudely, Category C includes what we would call quasi-adjudicatory local agency actions. So the California case law makes a distinction between legislative and adjudicatory actions. And these are sort of analogies to how other branches of government act. When you're doing a general plan, you're acting sort of like the legislature or like Congress because you're making policy. When you're looking at a permit, particularly where someone is consistent with general plan and zoning, you're acting more like a court. You are applying rules to a request from a private citizen for some sort of property interest, and you're not really making policy in the same sense as you would if you were starting from scratch on say, a general plan update. There are rules in CEQA and a body of law called the Permit Streamlining Act that apply to Category C. They used to have teeth that would make you have to comply with CEQA within certain time periods. That's really not enforceable anymore. So in theory, CEQA review for Category C items should be done within a year for an EIR after the application is complete. Almost never happens, and there's no penalty for not happening. But in theory, that's how that should work. So just to reiterate, these are elements of this definition of project. Direct effect on the environment or reasonably foreseeable indirect, and then one of these three kinds of actions. So if you have one of these, then you start looking for off-ramps, or you're going to have to go comply with CEQA. But you have to approve it, ultimately, to comply with CEQA. If you're just thinking about something and you never do anything with it, then you have to comply with CEQA. You could envision a general plan update, and if you never do anything with it, and it's just in your head, then obviously you don't have to comply with CEQA. But if you ever want to make it official policy, you've got to comply with CEQA before you make that commitment. Before you commit yourself to a course of action, you've got to comply with CEQA. Now, flip side of that is there's a statutory exemption for feasibility studies, because those don't lead to commitments. You're just looking at options. You're exploring potential avenues for policy, but you're not making a concrete proposal that you propose to actually carry out. And with private projects, what the courts say is that they're going to make you do CEQA early in the process. So, as I said earlier, if someone comes in and wants a general plan amendment and a rezone as part of their development project, the fact that they need those changes triggers CEQA. They can't go get the general plan amendment, the rezone, without CEQA and then come in and say, here's my tentative map application. CEQA is commenced early in the planning process. So here's a chart. I'm not sure if it's very helpful, but you see it in the CEQA guidelines. It's the series of off-ramps that I've talked about. Now, there's one statutory exemption which is so central to CEQA that people think it's built straight into CEQA, but it's actually a statutory exemption, and that's the exemption for ministerial projects. If your action as a governmental agency is ministerial, you don't have to comply with CEQA. What is a ministerial action? It's an action that a governmental agency takes once it is determined that a private application for some sort of entitlement meets all of the applicable standards, and the determination as to whether those standards are satisfied really doesn't reflect any particular judgment or deliberation on the part of the agency official as much as just ascertaining whether the rules have been followed. And another way to say that is the agency doesn't retain enough discretion to tell you how to mitigate the environmental impacts of your action. If you qualify, you get your entitlement. Yes?
Can you give us an example of a project?
Yes. The most typical example in most jurisdictions is a building permit. So in most communities, if you go to the counter of the planning department and say, I want to add a second story to my house, or I want to build a new house on a residentially zoned lot, and you show you meet the setback requirements, you meet the height requirements, you meet all the codes, the official code requirements for the type of wood and nails and all that kind of stuff, windows, and the official checks every box, and then under the ordinance you get your permit, there's no CEQA compliance. Now, the exception to that has been, there's been some court cases that looked at building permits for big high-rises in San Francisco and Los Angeles, and those communities have chosen to write their building permit ordinances in a way that retains discretion for their building officials because of the magnitude of these structures. And depending on the wording of the ordinance, if there is that amount of discretion retained, that'll defeat the notion that it's ministerial and make it discretionary. Other examples can be grading permits, demolition permits, but it all turns on how you write your ordinances. So there's sort of a policy decision to be made as you contemplate writing an ordinance on one of these sorts of approvals, where there's pros and cons of making it ministerial versus discretionary. The flip side of ministerial is discretionary. You get discretionary, you're subject to CEQA. If you want people to get permits quickly and without great expense, you write your ordinances so the approvals are ministerial. And that's good for the applicants. But to the extent you wish you could retain the ability to mitigate environmental impacts, you give that up. The price you pay for keeping that discretion is you got to do CEQA. Now, if you had a discretionary ordinance, and based on this lecture you said, geez, let's change that to make it ministerial, you'd have to do CEQA on the ordinance that converted it to ministerial. And I'll give you an example I'm familiar with in my own work of a process that has just recently been completed in Kern County, which is the big oil producing part of California. Until recently, oil drilling permits were ministerial. So you just file an application for an oil drilling permit. You got to drill for oil. And they started getting a lot of litigation down there. The environmental groups were after the oil industry. So the oil industry decided, we're going to write and propose to the county a very elaborate ordinance on how to mitigate the effects of oil drilling. And we'll do a big EIR. The county has to do a big EIR on that ordinance. But once that ordinance is in place, now you can still go get ministerial approvals, but they're conditioned to protect the environment to a much greater degree than they were before. So they now have a ministerial, fairly comprehensive ordinance, but they've written it in a way where it really is a series of checking boxes, and so there's no CEQA. But to get to that point, they had to do an EIR. So the importance of this statutory exemption is such that really you should think of CEQA as applying only to your discretionary actions. So the quintessential ones for local government are conditional use permits, tenant subdivision maps, conditional use permits, rezones, specific plans, community plans, general plan amendments. There's design review ordinances a lot of times that have some discretion. They may be limited to certain topics. And if your discretion is limited to certain topics only, then CEQA would only apply to those topics. So if your design review ordinance is the only discretionary action, and that only allows you to look at color and materials and things like that, and not traffic and not greenhouse gases, then your discretion is confined to just to those topics. And it's really a function of how the ordinance is written. So this is what I've been talking about. So we won't dwell any further on that. I have talked about this already. This slide is a little misleading. I didn't write this particular one to the extent that ministerial is really a statutory exemption. So ministerial should be sort of a subset of statutory. So I mentioned these statutory exemptions. Unfortunately, for lawyers and others, they're kind of scattered around different codes. Most of CEQA is confined in the Public Resources Code, but sometimes you find these exemptions in other codes. The guidelines are good, and they try to retrieve them all and put them in here. And so these are some of the primary ones. You'll see on there, ministerial is down there in column 1. Another one that's important to understand is emergency projects. So if there is a forest fire coming and you want to create a fire break, you don't have to go do a study on what it means to create a fire break because there's no time. So there's a practical understanding there that sometimes you just don't have time to comply with CEQA. There's trouble coming, and you got to do something to prevent it. Or in the immediate aftermath of a natural disaster, you can go clean it up without complying with CEQA. So now I want to talk about categorical exemptions a little bit.
Excuse me, would you say that one more time? In the immediate aftermath?
Oh, yeah. So for this emergency exemption, it applies to actions to prevent an emergency, and then actions taken in the aftermath of an emergency to deal with the consequences of an emergency. So there's been a mudslide on the road. You can go clear the mudslide. You don't have to do a study before you do that. So just as you can create a fire break when the fire is coming to you, that's to prevent the emergency or prevent damage from an existing emergency to you. So too, after the fact, can you go clean it up? Now, what you can't do, and this is something people tried, is landslide into a highway, and you're going to go repair this 2-lane highway, and you figure, well, while I'm at it, I'm going to turn it into a 4-lane highway. You can't do that because you've expanded the scope of the underlying infrastructure. You can put it back to the way it was, but you can't use this as an opportunity to go do a bunch of stuff that you otherwise would have to comply with CEQA on. So a lot of actions that come before government are subject to these categorical exemptions. And the first 5 here are probably the ones that come up most often in local government. So you have an existing facility, you're going to repair it, you're going to do something to it, expand it in a modest way, and there are certain parameters to it. Then you're not subject to CEQA unless, as I'll explain, there's an exception to the exemption. Replacing existing structures, small structures, minor changes to land that are not in sensitive areas. And then there's some of these things that are not in the category of having only minor impacts. Some of these are things that are environmentally beneficial. So you see 7 and 8 there. When agencies act to protect the environment, so what they're doing is a net benefit to the environment, that's also exempt. because CEQA is only concerned with adverse effects on the environment. So if you're doing something that's protective, then you don't have to comply with CEQA because you're doing what the legislature thinks is a good idea. There's 33 of these. One that's quite popular in cities is number 32, the infill exemption. That applies up to 5-acre projects within cities with certain qualifications. It doesn't apply to counties. This has been a source of lamentation to counties around the state that have large urban areas that are unincorporated. They're not eligible for this particular categorical exemption. So as I mentioned, there are exceptions to categorical exemptions. So these categorical exemptions are not absolutes. And so if someone's going to sue you for having relied on a categorical exemption, they're often going to claim you were subject to an exception. And so there's 6 of them. The one that gets invoked the most is number 3, which is known as the unusual circumstances exception. And what that essentially says is that if there would be significant effects on the environment due to unusual circumstances associated with a particular project, then that can take you out of the exemption. This has been litigated through the California Supreme Court recently, and the outcome was actually pretty favorable to the agencies. It has to go to the amount of deference courts will give you when you conclude there is not an unusual circumstance. So for someone to be able to successfully challenge a categorical exemption under that exception, they'd have to provide convincing evidence that circumstances were unusual, meaning that you as the fact finder would be persuaded by that. And then once they establish unusual circumstances, they would have to show that those unusual circumstances cause a potential significant effect on the environment. And then once you get to that question, there is no deference to you. The tie goes to the opponent. And if they produce substantial evidence from which it can be fairly argued that the project may have a significant effect, and I'll break that all down for you a little bit more, then you have to then you are looking at doing possibly an EIR, that you're not allowed to do the exemption. The issue before the Supreme Court on this was whether any evidence of a potential significant effect, any substantial evidence of potential significant effect, was per se unusual and therefore would defeat the exemption, and that was rejected by the court. So that was a big victory for agencies, because had the court gone the other way, it would have become much easier to defeat categorical exemptions. In reaching its decision, the California Supreme Court talked about the legislative history of the legislation that authorized the creation of categorical exemptions, and the court found the intent of the legislature back in the 70s then was really to create a class or several classes of projects that really were small potatoes and should not be subject to CEQA, and they didn't want that to be too easily defeated. They wanted a high threshold to be able to defeat those exemptions. Now, if you rely on a statutory or categorical exemption, or even if you conclude you don't have a project, you have the option of filing something called a notice of exemption, which has to be delivered to the county clerk's office and posted for the public to see. And if you do that, it creates a 35-day statute of limitations for someone to go to court. If you don't do that, there's a 180-day statute. So every day in every county, the county's doing things that are exempt from CEQA. You may not even think about CEQA. You just know that what you're doing is not subject to CEQA. You don't go to the trouble of documenting that, and you don't go to the trouble of posting a notice of exemption. You could, in theory, but there's not enough time and energy and resources. On the other hand, if you have a project that's very controversial, you legitimately and in good faith believe it's exempt from CEQA, but someone may challenge that, and you're aware of it, it's probably in your interest to go ahead and authorize staff to post that notice of exemption, because if there's litigation, why wait 6 months to bring it on, create a short fuse, and maybe if the 35 days passes and no one challenges you, then you're home free. Then the entitlement will stick. There's exceptions to the optional nature of NOEs, but only for certain exemptions. And the reason the legislature wanted people to file notice of exemptions for these particular statutory exemptions is that there's a contention that no one's using these because they're too filled with qualifications, And they only really apply in dense cities, so it's not a bit of interest to you guys. But it's just a way to get feedback to see if anyone's using these things. But in general, they're optional. So this is the statement of this general rule I told you about, where it can be seen with certainty that there is no possibility that the activity in question may have a significant effect on the environment. The activity is not subject to CEQA. This is the catch-all. You don't have a statutory exemption on point. You can't find a categorical on point. But you think, gosh, this is such a small project or such a benign project. You can rely on this one. The courts do say that if you're going to rely on this one, you have to explain yourself, because the potential for abuse here is such that you have a burden to justify relying on this. So if you're silent, if your record's silent on this, you say, we're relying on this, but with no explanation of the record, you're probably going to lose that argument in court. But if your staff writes a memo as to why this has such minimal impacts, then you greatly increase your chances of successfully defending that. Okay, so here's the definition of significant effect in the environment. And I mentioned earlier, this is a real central concept in CEQA. And as you can see, if you take a look at it, it's not that helpful. If you go to thesaurus.com and you punch in the word significant, you're going to get substantial as one of the synonyms. So a significant effect on the environment is a substantial effect on the environment, or a potentially substantial effect. So that's really not that helpful. What is helpful here is that what we're talking about is changes in the physical conditions of the area. So this supports the notion that we're talking about the physical environment and not social, not economic consequences. So the last sentence here says, social or economic changes in themselves are not physical effects. So here's an example where CEQA juxtaposes starkly physical effects versus economic and social effects. Now, from time to time in the legislature, someone proposes economic impact reports and things like that, social impact reports. My own opinion would be, if those were ever implemented, boy, you'd have so much paperwork to do. I mean, you got enough with CEQA. Those would cover whatever is not covered by CEQA, and then you'd have to study everything to death. Right now, we're focused on the physical environment. So how do you take this general concept and apply it to particular fact situations? Well, there's guidance in the CEQA guidelines. There are things called mandatory findings of significance, and these are actually not that well known by the public and even by environmental consulting firms, which drives me crazy because these have been around for 40 years and these people should know these. And they're enforceable by courts. So you have no choice but to comply with them. They're somewhat vague, which I guess is good news. They didn't used to be always so vague. There was one that, before it was changed, said that if you had a project that would reduce the range or restrict the range or reduce the number of an endangered or threatened species, that was a significant effect on the environment, with no qualification. And for a long time, that was thought to be, if there would be one dead listed species, you have to do an EIR. That was changed. Now it has to be substantially reduce the number or restrict the range. Cumulative impacts come under the mandatory findings. Substantial adverse effects on human beings as another mandatory finding. But again, that's vague. So they're not that helpful. They create a starting point for interpreting those terms. Then there used to be in the CEQA guidelines an appendix that had a list of impacts that was normally considered significant. And the courts interpreted that to mean those types of impacts were presumed significant, but the presumption could be rebutted. That list was repealed back in the late 90s by the Pete Wilson administration. And for the practitioners, it left kind of a void about how to define significant effect on the environment. So what the custom has become since then, although it's not required, is to take the questions in the sample initial study checklist, which you'll find in Appendix G to the guidelines, and turn these questions into declarations whereby the effect would be significant. And I'll give you an example. This checklist is organized in alphabetical order and has an environmental category starting from A for aesthetics, going not to Z, but to U for utilities and service systems. And for example, the first question under aesthetics is, would the project have a substantial adverse effect on a scenic vista? First question under air quality is, Would the project conflict with or obstruct implementation of an applicable air quality plan? Now, the way this checklist is set up, you can answer that question yes, and you don't necessarily have a significant effect on the environment. But what the consulting profession has done, for lack of other sources of guidance, is to take these questions and simply to turn them into thresholds. So under the examples I gave you, you would say you have a significant aesthetic effect if there is a substantial adverse effect on a scenic vista. So this checklist document is routinely used to come up with thresholds because it shows the topics that are of interest to the state, and it reflects the existence of other laws that sort of interact with CEQA, like the Clean Water Act, the Clean Air Act, Endangered Species Act, California Endangered Species Act. You do have the ability to fiddle around with these things. Often people don't, and there's a misunderstanding amongst a lot of folks that you have to do what I just described, but it's really optional. And I think you have the ability to fiddle around with these, but if you do, you want to explain why you've done it. And ultimately, courts are maybe going to review what you've done, and so you have to have a good explanation and substantial evidence to support whatever you're doing. Now, I'll give you an example of a question about biological resources. It comes up a lot. I'm sure in the county with so much beautiful land, it comes up here. Would the project have a substantial adverse effect, either directly or through habitat modifications, on any species identified as a candidate, sensitive, or special status species in local or regional plans, policies, or regulations by the California Department of Fish and Wildlife or the U.S. Fish and Wildlife Service? So the operative language there would be substantial adverse effect. Well, I've worked on projects involving fish and involving terrestrial species, and so what I encourage the fisheries biologists to do, or the terrestrial biologists to do, is take that term, substantial adverse effect, and give me more detail. What does that mean here for steelhead in this river? What does that mean? Or what does it mean for this mammal in this location? And they'll give you their best professional judgment. Now, your staff isn't required to necessarily accept that without question. They can have a conversation about it. And you can change the interpretation there, but whatever you do has to have substantial evidence to support it. And you can't run afoul of these mandatory findings. In general, because the courts always seem to err on the side of more protection rather than less, the lower you set a threshold, the easier to defend that's going to be. The higher you set it, the more skeptical a court might be. But as long as you have substantial evidence, you'd have a fighting chance of defending whatever you've done. So there's a lot of judgment that's brought to bear in this. In the first instance, you look to the professionals. But you as the lead agency get the final call. But I would warn you against at the last minute at a hearing saying, well, here's all this evidence from this fisheries biologist about this particular river and this particular species and what would be a significant effect. I would caution you against just disregarding that, changing that conclusion, and not having any countervailing substantial evidence to support your own conclusion. So there's a tendency to rely on the experts because they're the experts, but you are allowed to question their judgment and to have conversations with them. But ultimately, it's safer to err on the side of a lower threshold. Yeah, question?
I was just going to, you keep using the term substantial evidence. Is that typically expert opinion, testimony, whatever?
Yeah, thank you for the question. I realize now I should have defined that from the get-go. That is an example of jargon I'm using that I didn't define. And it's a very important term. And here's how I typically explain it. In the law, there's different levels of proof. So think of the highest level of proof. In a criminal trial, you've got to prove beyond a reasonable doubt that someone committed the murder. In a civil trial, where the defendant wants, or the plaintiff wants money from the defendant, I slipped on a banana peel on your driveway, give me money. You have to prove by a preponderance of the evidence that the defendant is liable. That means more than 50%. So I think 100% is absolute proof. Beyond a reasonable doubt, put O.J. Simpson behind the bars. Somewhere well above 50, but not 100%, beyond a reasonable doubt. Preponderance of the evidence is lower. That's why O.J. could be liable in civil court when he wasn't convicted of murder. Lower burden of proof. Substantial evidence is below 50%. Substantial evidence is evidence that is credible, solid, sufficient to persuade a reasonable mind, but not necessarily all reasonable minds. So it's evidence that you could rationally rely on, even if others might disagree with you, in good faith. You can have two experts, both have substantial evidence, and they're arguing for the opposite proposition. Expert A says, I think this is a significant effect in the environment. Expert B says, I don't think it is. In theory, they both can't be right, but they both have substantial evidence. Now, whether something requires expert evidence is a function of the nature of the topic. So the secret case law says that issues that require training and education and experience may require expert testimony. So if you had someone come in who had no particular training other than just a high school education and said, I've been running this air dispersion model in my spare time, and I'm predicting the plume for this project is going to go over here. And then you have a PhD who says, no, it's going to go over here. The first person with no technical training, they haven't credibly made that point. It's not the normal thing that they would be able to engage in that kind of technical analysis. So in that case, you could disregard their input because they just don't have the training. It's per se a technical topic, and they just don't have the ability to opine on that. On the other hand, if someone says, you're building a project in my neighborhood, or you're thinking about it, and there's going to be a bunch of traffic, and there's already too much traffic. I stood in the corner yesterday, and I counted 60 cars between 3 and 4 o'clock. Well, that person doesn't need training to count cars. That's lay testimony, but it's of the kind that lay people can testify to competently. So as you're presented with lay testimony and expert testimony, you have to think about the context and the nature of the testimony. If they're trying to be experts when they're not, you can disregard it. If they're speaking to something that doesn't require expertise, then their testimony may rise to the level of being substantial evidence. There's some gray areas. One is aesthetics, and this makes it hard sometimes to defend negative declarations. If a neighbor says, I've seen the project design, it's ugly, I think it's going to be ugly, there are some courts that would say, well, that's substantial evidence. It doesn't take a rocket scientist to opine on whether something's ugly. My own personal opinion is that's too low a threshold because it's all too easy for a neighbor to say it's ugly. If that's all it takes to get an EIR, then that's just too little. So I would argue you got to be an architect or someone with some training in this field to opine on that. But so there are gray areas. So now this last bullet here on thresholds of significance.
Let me back up a minute. Ugly's in the eyes of the beholder.
Right. But do you want to do an EIR just because a neighborhood lives next door to projects?
I mean, it seems like that's a ridiculous argument. I mean, what I think's beautiful, someone else thinks is ugly. I mean,
yeah, there's a split amongst the appellate districts. There is a case out of Berkeley, which is in the Court of Appeal in San Francisco, and that court said, building a 3-story structure in Berkeley that's subject to design review doesn't implicate CEQA. We're not going to let you say in the middle of this urban area with cement everywhere that a little bit more cement is so ugly that you got to do an EIR. In Sacramento, where I live, the Court of Appeal required an EIR where someone wanted to put in small houses in a neighborhood with big houses because all the residents in the big houses said the small houses would be ugly. And the court required an EIR. And I'm bitter because our firm lost that case. I just think, personally, that's too easy for people. One of the guys was an architect. I think it's ugly. And so the court said, do an EIR. So it's a gray area, but I'm skeptical because it's too easy. Okay, so moving right along. This last bullet says adopted thresholds. So in the 1990s, the concept of thresholds of significance gained some traction. And the idea, and it originated with environmental attorneys and consultants. The idea was we have this very general notion of significant effect on the environment. It's really hard to apply it to particular kinds of resources. So let's take it upon ourselves to define what a significant effect is in a particular context. Biology, air quality. And so the Resources Agency back in the 90s thought, that's a splendid idea. Let's write a regulation that says you can do that. And so that's what this regulation 15064.7 says. You as a county can propose a set of thresholds that would apply to all your projects, but you'd have to do that through a public process. You'd have to have public input, take testimony from builders, from environmentalists, from everybody, and then you'll try to settle on a set of thresholds, and then you'd apply those to all your projects. So that option was created in the 1990s.
Would that process be subject to CEQA, I assume?
You know, there was a decision in a trial court in Oakland that said it was, and that was overturned on appeal. So I don't think this is, because you're not really approving projects. You're just creating thresholds. Now, if someone doesn't like them, they could sue you. And this is not done very often because those public processes foreseeably would be somewhat contentious. So a lot of people don't seek out that sort of fun where you're going to be up there and be harangued by people from the left and the right and then be asked to make a hard decision. So it just isn't done that often.
You said if they didn't like them, they could sue us. Would that suit come as a suit under CEQA at the time of a project, or would it come at the time of us developing those standards?
It would come after you develop the standards. And the argument would be, since you set the standards at a certain level, things below them are going to happen more easily than things above them, and therefore you're causing the impacts.
But under what law would we be sued under?
CEQA.
Okay.
So that's what happened in this case in Oakland. There were thresholds of significance adopted by an air district, and California Building Industry Association didn't like them, and they sued, arguing you got to do CEQA before you do these thresholds. That was rejected by an appellate court, but it's not a published precedent. So I can't say I could point you chapter and verse to something I could say to a court. My own opinion is they're in that case they were really advisory. They weren't binding because they were an air district saying to agencies, cities and counties, we'd like you to use our thresholds. They couldn't compel it. So there's this process for creating thresholds, and you're free to do it. What's happened, though, over the last 20 years is because most lawyers who are in this business and consultants think you need thresholds in order to have a clear explanation of why something is a significant effect that would, in a way that would survive judicial review. People use thresholds without going through this process. And they typically use them from this checklist. And what I often see is jurisdiction X hires consulting firm A to do this job, consulting firm B to do this other job, consulting firm C to do this other job, and all those consultants use different thresholds. And the public might wonder, why is the same county using three different sets of thresholds? Well, three different firms. I personally think it makes sense to be more consistent. But if you're totally consistent, then someone could say, why didn't you do this process? So what the court cases say is it's okay to use thresholds in an EIR without having gone through this process because including them in one EIR doesn't mean that you're using them across the board. So you have this tradition where no one's following this legal process. Everyone's using the thresholds. It's good from a legal standpoint to have them because it makes it more clear for judicial review what your reasoning is and what your evidence is. But the cases say, well, you really shouldn't use them consistently unless you go through this process. So you're using them in all likelihood because the consultants find they can't do their work without them. So here's what a definite. I'm going to break in a few minutes for a coffee break or a bathroom break, but just to get this out. Here's the definition of a threshold of significance as per that reg. And basically it's just think of it as a line on a vertical continuum. High impact, zero impact. It's a line above which it's significant and below which it's not significant. So you draw that line and it acts, if you come in above it, you're probably going to do an EIR. If you come in below it, you could do a negative declaration. So I think this is a good place to break. I don't know if you want to do it for 10 minutes or 5 minutes. Or
Okay, we'll go ahead and take a 10-minute break,
Okay.
and we'll come back. Please be in your seats by 35. I'll call it back to order, and please proceed.
Okay. So now I've taken you to the point where you have found no off-ramps, and you're going to have to do initial studies. So just to really briefly, almost in an auctioneer-like fashion, summarize where we've come. You ask, do I have a project? You look at the definition of project to see whether the activity you're considering meets the definition. Am I thinking about approving it? Meaning, am I going to do something that commits us to a course of action? If I answer both those questions yes, I look for a statutory exemption. Can't find one? I look for a categorical exemption. Maybe I found one. Is there an exception? Oops, there's an exception. I can't use that categorical exemption. Is there the general exemption available? And if none of those off-ramps are available, then you're looking at a minimum of a negative declaration, a variation of which is a mitigated negative declaration, and maybe an EIR depending on the conclusions in the initial study and the input you get through public review. So an initial study is a checklist supported by explanation and facts. Appendix G to the CEQA guidelines is where you'll find the form that's recommended by the state of California. The state of California says it's only a form, it's recommended, you don't have to follow it. However, you do have to ask all the questions in it. So it's sort of saying it's not really mandatory, but then it really is kind of mandatory. So I think that what it does is provides you a set of topics that you need to address and a set of questions you need to ask. And as I mentioned, it's common to take those questions and flip them into declarative statements and treat those as thresholds, whereby an impact is significant if you meet that, but you're not bound to do that. It's a good source of information, and people go there because there's nothing similar to it that looks at environmental resources from A to U. But you can fiddle with it, but you should explain if you do. So if you think a negative declaration is going to suffice, you've got this initial study, you've asked all these questions, and you've reached the conclusion that there are no significant effects on the environment. And therefore, it's appropriate to send out a proposed negative declaration for public review. Now, a variation on that could be, it looks like there may be significant effects on the environment, but the community development director or the planning director says to the applicant, geez, looks like you may need to do an EIR. However, if you agree to certain mitigation measures and you promise you won't protest them when you get to the Board of Supervisors, you make them part of your project, then that'll squish that significant impact down to a less than significant conclusion, and therefore we don't have to do an EIR, and that's called a mitigated negative DEC. So negative DEC, there's no mitigation built into it. Mitigated negative declaration, there is mitigation built into it. Built into it in the sense that the applicant agrees to it. So you've reached the conclusion that you don't think there's any significant effects, and you're eligible for a neg DEC or a mitigated neg DEC, but then you put it out for public review. And these are details here that I'll skip over about what goes in the initial study, and forget this slide for the time being. You send that neg DEC out for public review. Well, suppose it turns out to be a highly controversial project. It seemed to the planning staff to be pretty benign, pretty small, but if you lived next door to it, you weren't too keen on it. So you get a bunch of comments from people who say they don't like it. As the agency, you need to really look at those comments to see whether anyone has provided substantial evidence that there may be a significant effect on the environment. So I use my example of the people with the big houses in Sacramento didn't want people coming in with small houses. Those people said, oh, it's ugly. And that turned out to be enough for the Court of Appeal in Sacramento. Now, some neighborhoods are more sophisticated than others. I find that if you were to try to do a project in Davis, California, Berkeley, California, any place with a major university, any Palo Alto, you're going to find neighbors who have PhDs on multiple subjects, So it's not just a neighbor saying, not in my backyard. They happen to be trained to pick apart your technical analyses. And they'll come to the podium and say, I've rerun your traffic model. I happen to be a traffic engineer, and I'm finding significant effects. Or I'm the world's leading expert on this particular reptile, and I saw one on your property. So these people are walking spewers of substantial evidence because it's such a highly educated citizenry. Now, you could go to some other neighborhood where you don't have those folks, and they don't have the same level of sophistication. They may not have the same level of income. They can't afford to hire a planning consultant to speak on their behalf. And you look at comments from them, and they're things like, we don't want the project, there's too much traffic, it's going to hurt our property values. You might look at that and say, there's no substantial evidence here that there may be a significant effect. We can proceed with a negative declaration. If you're in Davis or Palo Alto, you might find abundant substantial evidence because the people know that if they just use their expertise to pick at your technical work and then opine that there may be a significant effect, they're going to get that EIR. So the initial study is your preliminary take on it, but you ultimately, when the project comes to you, you need to look at the totality of the evidence, including the public input. So if you ask someone like me, what is my least favorite lawsuit to defend, given that I like to have a high winning percentage, it would be defending a negative declaration where it's in Davis or Berkeley or Palo Alto, and I've got all these people with all their PhDs saying why you shouldn't do the neg deck and why you do the IR. So this is all talking about what's called the fair argument standard. And this derives from a statutory statement that an EIR is required where there may be a significant effect on the environment. And the California Supreme Court in the 1970s looked at that word may and contrasted it with will, and understood the legislature by using the word may to be suggesting that the reasonable possibility of a significant effect is really what triggers an EIR. And that can occur when it can be fairly argued based on substantial evidence that there may be a significant effect. Now, in some instances, that requires expert testimony, as I described before the break, depending on the topic. In other instances, lay testimony may be sufficient. And the important thing to understand as a decision-making body is that when you're confronted with this fair argument that there may be a significant effect, the courts say you then have a legal duty to prepare the IR. You're not asking who's right or who's wrong on the question of whether there's a significant effect. You're confronted with this conflict in the evidence, and if someone has made the requisite showing, they can fairly argue based on substantial evidence that there may be a significant effect, you have to do the IR. You might even disagree with what the opponents are saying. And given the chance to be the fact finder, you would say, no, you disagree with them. You don't get to be the fact finder at that point. You then have to do the IR. And once you're in an EIR, you become the fact finder, and you get deference in your ultimate factual technical determinations on an EIR, whereas you don't get that deference on the question of a negative declaration. So this is the part of CEQA that the environmental community and their representatives in the Capitol are most fiercely attached to. It's a very powerful thing for them. It allows them to force EIRs where they are willing to expend the resources to bring in experts and things like that. And when the legislature even thinks about changing this, the environmental groups marshal their forces and emails rain down on the Capitol. Don't touch this. And there have been a few attempts over the last 20 or 30 years, usually when recessions hit, to maybe address this issue on the theory that there's too many EIRs, it's not good for the economy, and it becomes a real pitted battle between the environmental interest and the business interests. So I guess the short message is if you have a really controversial project and the opponents seem to be in it for the long haul, you may end up doing an EIR, and you may think about even not trying a neg deck. And so if I were advising a developer as opposed to a public agency like yourselves, I would tell the developer horror stories I've had of clients who've tried a neg deck, then they got comments, then they did another neg deck to try to incorporate the comments, Then they got another set of comments. They did 3 neg decks. Finally, they said, let's just approve it. They got sued. They lost on the neg deck. They had to pay the attorney's fees of the petitioner's counsel. And then they had to go do an EIR. They had to pay for the EIR. And then that takes a long time. And so you look back in retrospect and said, boy, if you just done that EIR right off the get-go, you would have saved a lot of time and money. There's a provision of CEQA that says controversy by itself doesn't trigger an EIR. But as a practical matter, if you have controversy and you have sophisticated people, it might be a prudent thing as a business strategy for an applicant to just go ahead and do an EIR. And so your staff might talk to an applicant. You know, you got all these neighbors are up in arms over this project. The environmental groups are unhappy. We think a neg-deck might be okay, but we don't know what the comments are going to be, and you might want to just consider doing an EIR. So this is really the guts of the whole issue with a neg-deck. It's this fair argument. It all derives from the word may in CEQA, and it's like the third rail of politics on CEQA. This is a case I include here. If you go back to the 70s and 80s, these initial study checklists literally used to be a bunch of check marks. They'd be all these questions, and the answer would be, is this impact going to occur? Is that impact going to occur? And there'd be yes, maybe, or no. And someone would check everything no, and then they'd sign their name at the bottom. And the court said there's no substantial evidence there. You could train a chimpanzee. They didn't say this, but I say this. You could train a chimpanzee to have check marks. The mere fact that you answer everything no with no explanation doesn't give the courts anything to sink their teeth into. So now a good negative declaration, a good initial study will be pretty beefy. It won't have just the answers yes or no, or now it's potentially significant and less mitigated, less than significant, no impact. If you don't have explanation and evidence to support your conclusions, the courts are probably not going to uphold your action. So now you have these checklists with supporting documentation. Sometimes a neg deck can be this thick. They used to be this thick. They got a bad reputation with the courts back in those days, and a lot of judges still disfavor them, even though they are mandatory where there is no substantial evidence of a significant effect. The environmental groups fight over these all the time, and so there's just a notion that EIRs are better. EIRs are more of a vehicle for public input. I personally think it's kind of a bias of the courts. I was at a conference recently and asked some question, and one of the responses from one of these court or appellate justices was just do EIRs, just do EIRs. So that's kind of the attitude some courts have. So I'm been talking about all this stuff. Oh, one thing I want to add, there's an issue of when do you have to recirculate, and it's not a slide here, when do you have to recirculate a neg deck? And there's a parallel requirement to recirculate EIRs in some instances. And so recirculate means you've done public review, the 30-day process, you got to do it again. So if you had, on a neg deck scenario, an initial study that said no significant effect, and then the neighbors hire experts and they come up with a fair argument that there may be a significant effect that's supported by substantial evidence, and then the developer says, or the agency says, okay, we'll do a mitigation measure to address your concern, and that's added at the end of the process. But for that mitigation measure, you'd have to do the EIR. Under CEQA, you'd have to recirculate that negative declaration one more time with the mitigation measure in it. So that's a reason why there's a certain amount of risk associated with doing a neg deck, because if you find you need to bulk up the mitigation, there's a penalty. You're going to go back and recirculate. That's not true of recirculation of EIRs. You can only be forced to recirculate an EIR where there's essentially new information showing a new significant effect, and you can mitigate your way out of that, but that's not the case with neg decks. So there's a lot of reasons why you may end up doing an EIR for big projects. But I've talked about all the off-ramps and all the filters. But so now let's assume we have to do an EIR, and we'll start talking about the requirements of EIRs. So you'll see here from the third bullet, there's multiple kinds of EIRs. The two most common are the project EIR and the program EIR. And the distinction there is that a project EIR is intended to be sufficiently detailed that it is the only or it's the last CEQA document you need to actually go out and move dirt. You've looked at the site at issue with enough specificity. You know where the plants are. You know where the animals are. You're not at 30,000-foot elevation. You're down in the weeds. You know what the resources are on the particular site. A program EIR is more of a 30,000-foot elevation, and it's typical for things like a general plan where it's not practical to survey every plant in the county or every critter. There's just not enough time and money for that. And so you're dealing with more of a broad brush, and what you're doing is you're creating kind of an analytical superstructure that you can then build on to drill down further in connection with later projects. So very common to have a program EIR for your general plan, and then once the general plan's in place, a developer will come in and say he wants to build or she wants to build a certain number of houses in this particular area. You can take your general plan EIR and see what it said about that particular area and then build on that, drill down, look at the site-specific issues. We've now done a rare plant survey for that property. We've looked for the animals on that property. And then you do a project EIR tiering from or relying in part on that program EIR. There's a whole variety of other types of EIRs involving attempts to streamline CEQA. So one of the issues over the years with CEQA has been how cumbersome it is. Isn't there a way to make it more efficient? And the legislature and the resources of agencies, they've tried to invent mechanisms to streamline CEQA. And it's almost like there's a law of unintended consequences when they do that sometimes by trying to simplify it, they make it more complex. So it's taken me a lot of brain damage over the years to get my head around all the different ways to simplify CEQA because they're so complex. And I don't have time to deal with them here, but just be aware there are those things out there. But you'll need to rely on your counsel on those. The last two examples of EIRs here, and then the reference to an addenda at the end, those are documents that are part of what's called supplemental review, which is something I want to have a chance to talk to about today in depth. But supplemental review occurs where you've already done one round of CEQA for a project, and then the project doesn't get built for some reason for a while, and the applicant wants to tweak it and comes in for another approval to reflect the modifications. In that instance, you're not subject to the fair argument standard, and the question becomes, are there new significant effects or substantial increases in the severity of previously disclosed significant effects associated with a change? And if there aren't, you don't have to do that supplemental EIR. You can do an addendum. And so the idea is once you've done an EIR, you're contemplating a certain level of environmental impact. And even though it hasn't happened yet, under supplemental review, when someone wants to tweak a previously approved project for which there was an EIR or a negative declaration, you sort of treat the impacts that you've already come to grips with as a given, and you're only asking whether they're going to get worse. And so this is a much more forgiving and lenient approach from the agency standpoint, a lot more deference that you're going to get. You don't have this hair trigger for an EIR like you do the first time through with a fair argument standard where it's kind of a low threshold to do an EIR. And the reason for the different rules is that the legislature seems to believe that once you've gone through CEQA once, they're not going to make you do it lightly again. It's like you've been through purgatory, you've suffered enough, you don't need to do it again lightly, unless you're going to have new impacts. Now, the contours of this actually are currently before the California Supreme Court, and we're expecting a decision from them in the next 6 weeks or so, the first time they've really weighed in on supplemental review. And one of the questions there is just how deferential they're going to be to public agencies when they choose not to do supplemental review. So stay tuned for that, or I'm sure your staff will. So I'm going to skip over all this stuff about neg decks and get to EIRs. Well, actually, I'm changed my mind. Before I leave neg decks, when you have a mitigated neg deck, just as when you have an EIR that produces mitigation measures, one of the documents you need to adopt as part of project approval is something called a mitigation monitoring and reporting program. And what that basically is it's a list of all the mitigation measures that you're approving, and it describes the timing of when they will be implemented, and it creates a mechanism for a feedback loop by which the agency will be notified when the mitigation measure has been implemented. And the reason for this was that in the late 80s, some scholars did a study of how well and how much adopted mitigation measures were actually being implemented by developers after they were approved. And turned out a lot of them were just ignoring the mitigation measures. There wasn't enough enforcement from agencies. There weren't enough inspectors to keep an eye on whether they're actually doing all these mitigation measures. So they created this mechanism as a way to ensure the implementation of mitigation measures. So the way these slides are set up, there's a discussion of mitigation here, and I think maybe I'll talk about it. This kind of applies to mitigated neg decks and EIRs, but since the slides are set up to talk about this now, I'll go ahead and do that. So there's a definition of mitigation. There's different ways to address significant environmental effects. One is to simply avoid doing the damage. There's a wetland on your property, you're a landowner. If you build around it, that's avoiding it. If you go to the last example, compensating it, if you fill that wetland, you may have to create a new wetland somewhere else. That's a form of compensation. So there's all these different verbs of what you can do: avoid, minimize, rectify, reduce, compensate. These are all legitimate forms of mitigation. Sometimes you pay a fee as mitigation. A very common thing is traffic impact fees. I'm not sure how it works in your county, but in a lot of places you have a circulation element with a list of road improvements that's going to be implemented over the time horizon of your general plan. And each development that gets approved is going to contribute to the demand for additional capacity. And you try to ascertain the fair share contribution of that particular project to the overall need. And then you assess them a traffic fee so that that money accumulates, and when the improvement's needed, that applicant has put in his or her fair share. So that's a very common form. Payment of a fee. I think in general, developers would prefer to write a check than to go and find their own mitigation lands and things like that, build their own facilities. Not everything is reducible to fees, but so this is the general definition. Another thing I want to mention, and this goes to the last couple of entries on this slide, is there are constitutional principles lurking in the background when you're doing mitigation for private development projects. So someone brings you a proposed development, and there's some significant effects on the environment. You got to be aware of the constitutional backdrop. There's a danger of engaging in a regulatory taking if you're overzealous in seeking mitigation. There's two Supreme Court decisions, U.S. Supreme Court decisions from the late 80s, early 90s that speak to this, the Nolan and Dolan cases. The Nolan case was a case that stands for the proposition that before you can require an exaction or some sort of mitigation from a project proponent, you have to show that the mitigation is aimed at a harm caused by the project. In other words, you can ask someone to clean up a mess they're going to cause, but you can't use your leverage over them to take more from them than is necessary to clean up their mess. And it used to be before the Nolan case, there was a line of cases in California. There were two lines, but one of them said that if you were before the government and needed an entitlement, the government could extract from you anything that served a legitimate public purpose. So that would be an exercise of raw leverage. You need a permit from the Coastal Commission to add a second story. You've got to give us your beach. That was the fact situation behind Nolan. And the Supreme Court said, no, there's no relation between adding height to your building and people losing access to the beach. The Coastal Commission can't take your beach just because they want it. They have to show that your project is somehow impeding public access to the beach, and it's not. So that line of California cases went away. And so this is the notion that when the individual is standing before the Leviathan government and the government is trying to impose things on an applicant, this Leviathan has to have limitations on its exercise of power because it's an unequal bargaining situation. So this principle of nexus limits the ability in this ad hoc situation to go beyond asking for amelioration of the harm the project would cause to just get goodies that you'd like because you'd like to have more money to do good things. Following Nolan, there was the Dolan case. Just a coincidence that it rhymes and it's a catchy thing, Nolan Dolan. In Dolan, the U.S. Supreme Court addressed the question of assuming nexus, and you get to require a mitigation or some sort of exaction or tribute from an applicant, how much can you take? And essentially the principle is that the amount of mitigation has to be roughly proportional to the extent of the harm. So if you cause this much harm, your mitigation should be this much. So there's got to be a nexus, and the mitigation's got to be roughly proportional. Now, there's a later case, which is a California Supreme Court case interpreting these federal cases, but it's pretty much consistent with later U.S. Supreme Court cases called Ehrlich. And Ehrlich said, well, if you read Nolan and Dolan, they're really mainly about situations where there's ad hoc mitigation imposed. And if you instead, as government, are applying an ordinance you have, like a tree ordinance or some sort of grading ordinance to a project applicant, and maybe there's not the totally tight fit in terms of rough proportionality, it doesn't need to be that tight of a fit because you're not doing it on an ad hoc basis. You're relying on an existing set of rules. And the reasoning in Ehrlich is that unlike an individual up against the Leviathan where it's unequal bargaining leverage and a danger of overreach by the government, when an ordinance is proposed, it can mobilize an entire industry to defend its interests. So if you're proposing a tree ordinance, you're going to have typically representatives of building organizations, development organizations, as well as environmental organizations. And they can put up a pretty good fight, and they can presumably have input that would lead to their position at least being reflected in part in the final outcome. So there's not this great inequality of bargaining strength when you're just taking something off the shelf that you've already adopted and imposing it on an applicant, as opposed to fashioning mitigation out of whole cloth for a particular applicant on an ad hoc basis. So I talked a lot about the concept of feasibility, and this is a good time to get into some of the details. I think this is a very important concept. It comes up more on EIRs than mitigated negative declarations. So here's the definition of feasible: capable of being accomplished in a successful manner within a reasonable period of time, taking into account economic, environmental, legal, social, and technological factors. This has been a source of a lot of litigation, and from my standpoint, it's moving in the right direction in terms of preserving the legislative prerogatives of agencies and not putting them in straitjackets, and I'll explain that. So the courts have developed differing concepts of feasibility. And one that gets a lot of play in the case law is the concept of economic infeasibility. And the case law here really has primarily been developed on the backs of private development projects, but more recently this has been applied to public agencies on public projects as well. And so here's the legal test. And this would apply to mitigation measures or an alternative that's before an agency. And the question is it too expensive, or would it hurt the profit margin too much? So after many years of case law, this is the test. Are the marginal costs associated with a mitigation measure or alternative, as opposed to the project without it, so great that a reasonably prudent property owner would not proceed with the project if they had to do that? So if you're a sophisticated investor and you've got this housing development, and now there's a concept, okay, you're going to have to go do this really expensive mitigation. Is that mitigation so expensive that you would just abandon the project if you had to do it? The rate of return, the level of risk is too great. The level of risk is too great, the rate of return is too low. Or could you absorb it and still have an economically viable project? So that's the test. It's a pretty severe test. And as you might imagine, applicants are not too keen on it because there's kind of a built-in notion that you shouldn't be making too much money. If you're making all that money and you've got significant unavoidable effects, maybe you should plow some of that money back into mitigating the effects of your project. So environmental opponents have used this economic infeasibility test to try to extract a lot of stuff from applicants and agencies saying, hey, it doesn't kill your project, therefore you need to do it. So that's one category of feasibility. There's another category I call policy and feasibility. And this is what has been particularly hard fought in the courts. The environmental interests have really resisted where the case law has gone on this because they think it creates loopholes that makes it too easy not to mitigate or too easy not to do alternatives. But the courts have accepted this. So that the lower bullet goes back to a 1982 case where the city of Del Mar had sued the city of San Diego over a housing project and basically said it was too dense. There was an alternative in the EIR with many fewer units, and you rejected that alternative because you didn't like it, and that's not a good enough reason. It wasn't economically infeasible. You should have done it. And the court rejected that, and the court said that what the city of Del Mar was arguing that was that infeasible is not the same as undesirable. It's something different. And the court said, well, it really doesn't necessarily have to be something different. If you think a policy outcome is undesirable, that can be a basis for rejecting a measure or an alternative as infeasible, provided that you can show you've engaged in a reasonable balancing of competing environmental, economic, social, and other considerations. So you've thought about how to balance various policy considerations, and you've determined, in that case, that a higher density outcome was better because there was a growth management program in San Diego that favored a higher amount of density in order to preserve land. The more units you can cram into a certain piece of land, the more market demand you focus in an area, the less sprawl you're going to have. That's the theory. And so that notion of policy and feasibility was created back in 1982. It's recently had some life put back into it, so this is now something the courts are pretty much universally recognizing. The first bullet here is a variation on that, the idea that undesirable outcomes are infeasible. But this is based on failure to meet project objectives. And so this puts a great premium on identifying your project objectives at the inception of the CEQA process. And as I'll get into, when you're in an EIR, one of the requirements is to articulate project objectives. And yet another requirement is to formulate alternatives to your proposal, your proposed project. And those alternatives need to meet most of the basic objectives while substantially lessening at least one significant effect of the proposed project. So someone like me who sees litigation coming, possibly for a controversial project, would recommend that a great deal of thought be put into those policy objectives. And the way I would recommend that a policy body such as yourself would go about it would be to think about the potential trade-offs that might be presented to you ultimately with the project coming before you at the time of approval, and think about what might persuade you to go ahead and endure environmental effects in the name of the greater good, and then to bake that stuff into your project objectives. So for a typical housing development, you might have project objectives of helping the county to meet its general plan goals for housing development, providing living quarters for families, providing jobs for construction workers. If you change the project to now it's a retail project, it could be to maximize sales tax revenue to provide money for services. And so you bake that into your project objectives, and then ultimately you have alternatives that meet some of those objectives, but not as fully as the proposed project. And then here you are at the time of decision making, and CEQA says, oh, these alternatives have fewer impacts. So if they're feasible, you should adopt those instead of the project. Well, you can say, well, this particular alternative doesn't meet the objective of generating tax revenue to the same degree as the proposed project, or it wouldn't create as many jobs. And those are legitimate factors for rejecting those alternatives as infeasible. But in that situation, you are relying on objectives you've already included in your EIR. So one challenge there is if the staff is preparing the EIR and they're coming up with the objectives, they're going to try to be clairvoyant and anticipate what the elected body would find to be the true bases for approving a project with impacts. So it's, for a big project like a general plan update, it's not a bad idea to seek input on something like that in the inception of the process, just so that you don't have a situation where the staff has identified objectives that when it comes to you don't agree with, and maybe you feel hamstrung by them. But that would be kind of a rare thing. And the more typical thing is you're going to get them, and they're going to say what they're going to say. But if you have staff who know you guys well, then they'll have a sense of what might be persuasive to you. So as I say, this policy feasibility is something that gets invoked all the time. The courts are going along with it. The environmental groups really don't like it. And I have some opposing counsel who still refuse to concede that this body of law exists and still argue against it. But I think it's pretty well established. Okay, so wanted to get that out there. Now we'll talk about the EIR process, and I got about a half an hour to do this before we open this up to questions. So there's a process. There's a step in the EIR process you don't have for negative declarations, and that's called the scoping process. And that is initiated by something called a notice of preparation, or NOP. And that's a notice that's sent to responsible agencies, trustee agencies, members of the public who've asked for notification of various CEQA notices, and generally the public at large. In the early days of CEQA, scoping was more of a private conversation between agencies to which the public was sometimes invited. I think over time the custom has been to invite the public. And then for certain types of projects, you have to invite the public. There are projects within CEQA called projects of statewide, regional, or area-wide significance. These are defined in the CEQA guidelines. And these are bigger projects that have certain levels of impact, a certain magnitude of projects. They often have impacts beyond one jurisdiction. And so the scoping meetings for those have to be public. My own sense is probably you want to have public participation in all your scoping meetings. It's, if nothing else, it's enlightened self-interest. I think it's good public policy. But if people have concerns about your project, I think it's best to hear from them early rather than have them be surprised later. Because you can often get things out on the table and work out problems if they're laid out early enough. And from the standpoint of applicants, they can get pretty dug in on the project they want to approve by the time they have approved. By the time they propose it to you or it gets to final EIR, it's the way they want it. They don't want a smaller project. But if they hear from the neighbors early, maybe they can find a way to deal with some obvious concerns like noise impacts and traffic impacts. Maybe they can redesign the project early and diffuse any concerns. The ostensible purpose, though, of scoping is to ascertain the scope of the EIR. What should the EIR include? So this is a place where this interagency conversation begins, where the state agencies who have some piece of the project, the Department of Fish and Wildlife, Regional Board, whatever it's going to be, they will say, here's what we need you to put in your EIR, so when the applicant comes to us for what we need to give them, we'll have the information we need. And then members of the public can offer their input too. As a practical and legal matter, you need to pay close attention to what the responsible agencies ask for. They're ostensibly entitled to what they ask for if it's reasonable and it's consistent with their statutory mission, and what they're asking for is feasible to do. Members of the public don't have that same standing. They don't need to use your environmental document for a permit, but they may have very good ideas. And if the goal ultimately would be to try to avoid a lot of controversy and unhappiness at the time of project approval, it's just good to get their input early. There may be a way to try to make everybody happy. That certainly doesn't always happen, but it's worth a try. So the NOP sets up a 30-day period for input to come in from the agencies and the public. You have a scoping meeting sometime during that process. And then once you have that, you prepare your draft EIR based on that input. Draft EIR is released. It usually takes several months after scoping to prepare, and depending on the complexity and size of the project, it could take longer than that. Then you circulate that EIR for public review. And typically that's for at least 45 days. in theory, it could be for as few as 30 days, but only if there's no need to consult with any state agencies. And I've seen situations where agencies thought there was no need to consult with a state agency because they wanted to save 15 days, or there was a developer pushing them real hard. I don't want to spend that extra 15 days. And then it turns out you should have consulted with the state. And if no one else, Department of Fish and Wildlife, because of its trustee role, because the project could affect wildlife, and you could lose that lawsuit. And so you can have a developer, presiding over the wreckage of his project 3 years later, having to pay a lot of money for attorney's fees for losing a lawsuit, all for having saved 15 days during public review. Those 15 days loom large when you're in the application pipeline, but in retrospect, when you have lost in court over that, you'll typically rue the day you value those 15 days more than having a more bulletproof approval. So you have the input on a draft EIR. People write comments. Unlike with a negative declaration, you have to respond in writing to those comments. The final EIR becomes a compilation of the comments, the responses to those comments, and then quite frequently errata, which may be a misnomer, but changes to the EIR based on public input. A draft EIR is a good faith effort, but it's a draft document, and sometimes it doesn't get everything completely right, and so you get input from agencies, and the public will say, well, you got this fact wrong, or you got this fact wrong. So you fix that in the final. People may have good ideas about mitigation. You can incorporate those. So the final pulls together all this public input, changes to the document, and then that ultimately gets served up to the final elected or appointed decision maker, whoever that happens to be for a particular project. If there's any legislative action, it's going to come to the Board of Supervisors. And then before you can approve the project, you would have to certify that final EIR. And certification is a three-part determination. And the three parts are: the document is legally adequate, you are familiar with it, you have read it, and third, it reflects the independent judgment of your agency. The reason for that third requirement is there to ensure that in those situations where an agency does accept a lot of input for an applicant, perhaps in the form of an administrative draft, a draft EIR, that the agency hasn't just passed that through without looking at it, but has studied it and can vouch for its agreement and acceptance of the conclusions in the document, either as originally submitted or as modified. Once you've certified the EIR, you're in a position to approve the project. You don't have to, but now you can if you choose to. If you do choose to approve the project, the procedural requirements include the adoption of a mitigation monitoring program, the adoption of CEQA findings, which I'll explain, and then the adoption, if you have significant unavoidable effects even after mitigation, a statement of overriding considerations, which is something I talked about earlier. That's where you say, we're going to approve the project notwithstanding these unavoidable significant effects because we think the project provides benefits to our community, and here are what those benefits are. Then once you've done that, you've got an approved project, and you have to file something with the county clerk called a notice of determination within 5 days of your action. And that's the document that, when posted at the county clerk's office, will commence a 30-day statute of limitations. So that's the process. I'm going to try to break these requirements down in the time I have available. Here's another list of EIRs, and reinforces my point that there's lots of different types of EIRs, very complicated, that I don't have time to deal with. This stuff I've skipped over. Okay, so here's contents of an EIR. I'll just let you look at the list here, and then I'll talk about some specific items in more detail. So I'll just let you soak that up for a second. Okay, so now breaking them down item by item. Table of contents, pretty straightforward. The summary is something that's probably of great interest to the decision-making body, because it pulls together the conclusions of the EIR and gives you the most important information. What are the significant effects? What are the mitigation measures? What are the alternatives? What is the controversy that remains? What issues need to be resolved? So when you certify an EIR, you say you're familiar with the document. I'm currently working with the state on a water project where the EIR is 35,000 pages. And it may be that the department director is going to read all that, but it would take him a year of nonstop just doing nothing but reading it. So that for him, the summary is going to be hugely important. So it's really intended for the person who doesn't have time to read everything, and it should crystallize the remaining issues for you if it's done properly. So you describe the project. This is pretty obvious. You need to know what you're talking about. Someone's proposing something. Well, where is it? What is it? You need a statement of objectives. I've talked about the importance of that already. That's really a very important part of the project description. And then another thing you put in there is how many permits are going to be required for this? Who beyond the county? What other agencies need to approve a piece of this? Do you need state approvals from various agencies? If so, what are they? So this is a roadmap to all the actions of various agencies needed before this project has everything it needs to go. Another requirement, environmental setting. This is just a description of the land at issue, the surrounding areas. There was a court case 20 years ago where a court said the environmental setting portion of an EIR was deficient because you couldn't tell from the EIR what the surrounding area was like. It turned out there was a river and riparian area nearby. You couldn't tell from the EIR that was in a sensitive location. So that was inadequate. That's pretty rare for that kind of argument to prevail. Where you get a lot of litigation is the timing of when to take a snapshot of the environmental setting. This is called the baseline. A lot of litigation over this. It's getting reasonably well settled because of all the court cases, but essentially CEQA is concerned with the impacts of a project on the existing environment. So the existing environment is the baseline. You put the project on top of it, then you ask, what are the impacts of doing that? Well, what time period do you take that snapshot? It's the time of the issuance of the notice of preparation. So when you send out the NOP, that is the time when you're allowed to say, we'll take a snapshot of the environment today, and that's our baseline. Now, you can move that up if you like. If you have a long CEQA process, and you want to update and it takes 3 years, say, you want to update some of your stuff, you can. There are certain limited circumstances, which I don't have time to get into in detail, where you can push your baseline a bit into the future, but you do that with some trepidation. But essentially, time of the NOP, what would the project added to that environmental setting do in terms of impacts? So what are the impacts? So this is key. Again, the concept of a significant effect comes up. We've already talked about thresholds, so you may have those there. And so I want to spend some time talking about direct, indirect, short-term, and cumulative effects. I know the board's interested in cumulative, and it's a really hard issue. And I don't have any silver bullets on how to deal with it, but I'll at least identify the conundrum we all face here. So I've talked about direct and indirect impacts when I talked about definition of a project. That's pretty intuitive. These are impacts from the project. I'm going to have a footprint of my project. I put it right on top of a pristine piece of land. It's pretty clear what the direct impacts are. The indirect effects are just reasonably foreseeable things that may not be happening directly, but I'm going to attract traffic. There's air pollution from traffic, so that's an indirect effect. Growth inducing, on the bottom here, that's an example of an indirect effect. Sometimes if you oversize infrastructure, you send a signal to the marketplace that land now may be more suitable for development than it might have been otherwise because now there's a sewage treatment plant nearby or a water plant or there's a pipeline nearby. So if you have a development that extends infrastructure out to an area that now there'll be some speculation and possibility of developers buying it up and wanting to come in and get approvals. That's the kind of thing that you need to lay out as an indirect effect. Distinction between short and long term is something CEQA requires you to look at. Example I use for that is project is going to require elimination of a bunch of oak trees. Oak trees can be replanted. But if you chop down a 300-year-old oak and replace it with a sapling, it's not really the same. But over time, these saplings will become an oak woodland. So you may have a short-term significant unavoidable effect and a long-term less than significant effect because over time the resource will mature, this new resource. So that's an example of this distinction. So now I want to talk about cumulative, and I know this is of interest, and I would say that this is maybe the hardest issue under CEQA. Let me talk conceptually about it. So cumulative impacts require you to look at the impacts of the project together with the impacts of past, present, and probable future projects. So you look out in time, you look forward in time. In a few instances, the courts have said you need to look back in time. Usually you don't have to catalog everything that's happened since statehood to get to where we are now, but there have been instances where in logging situations, the court thought it was useful to talk about how the forest got to its current condition. But in general, you have a baseline condition, and you're looking in the future, and then you're looking out spatially. So forward in time, looking out to a larger area. And then there's a notion that you do a two-step analysis to see whether the project is contributing to cumulative impacts in a way that in itself is a significant cumulative impact. So to use some jargon, the first question is, will the impact of the project together with all these other projects cause a significant cumulative impact? So, you know, if the trend line is downward and the future looks bleak and there's a lot of bad stuff coming from the standpoint of environmental impacts, you might say, yeah, there's a significant cumulative impact from all these things that are foreseeable. So that's the first step in that analysis. The second step is to ask the question, is the project's incremental contribution to this bad outcome, its percentage contribution, is that itself cumulatively considerable, which is jargon, but it means significant in and of itself. And there's a notion that you could look at a project in isolation, not looking to the future, not looking in a more expanded geographic scope, and say, it doesn't look that bad. I don't think it's significant. But now that you're revisiting that question, looking into the future and looking far afield geographically, gosh, it looks worse than we thought when you see that there's this downward trend. And so there's been a lot of discussion of what is a cumulatively considerable impact. And it's the hardest issue there is because from a philosophical standpoint and a logical standpoint, you might conclude that a small amount of cumulative impact, a small incremental contribution to an already bad situation seems worth worrying about. But if you say that that incremental contribution is itself a significant impact and you can't mitigate your way out of it, then you need to do an EIR. And so if you have too low a threshold, you have this practical problem of every discretionary action you take requiring this expensive, time-consuming EIR. And so if every little mom-and-pop project that has a discretionary governmental decision associated with it requires an EIR, then it's loading up entrepreneurs with a lot of costs, and it's not good for the economy. So what we've been struggling with for 25 years is try to find that sweet spot where you don't set it too high to be legally problematic, and you don't set it so low that it's impractical, and you've made yourself unable to do anything without an EIR. There's a case going back 25 years dealing with air pollution in the San Joaquin Valley, a case called Kings County Farm Bureau versus City of Hanford. Fact situation there was the project was a cogeneration plant. It was going to be a coal-fired power plant tacked on to a tire manufacturing facility. The concept of cogeneration is you take excess energy and heat from a manufacturing facility, you can use it to turn turbines, and then you can add a fossil fuel component to that as well. So here you have a very polluted airshed. You're bringing coal to it. You're training in coal from Utah. Then you're trucking the coal from the rail station down to the new power plant. Employees and visitors drive to it, and it has a smokestack and emits coal byproducts. In that case, the agency who did the EIR claimed there was no significant cumulative air quality effect. And their reasoning was that the air pollution was so bad already that even adding a coal plant would only add, from a percentage standpoint, a small percentage contribution to the overall problem. And the court rejected that reasoning on the theory that, what you're saying is the worse the situation is, the more you can add to it without it being significant. Where you have such a bad situation to begin with, why not ask the question whether a really small contribution would be cumulatively considerable? In fact, the court said the question would be whether any air pollution in that situation would be cumulatively considerable. So the court said you have to ask that question. A lot of people took that to mean that one molecule of air pollution in the San Joaquin Valley is a significant cumulative impact. The courts later said, no, we didn't say that. But they've never really articulated what is the sweet spot. And it really is going to vary from issue to issue. One option you have is if you have in place plans and policies that are intended to fix the problem eventually, and the project will do its fair share towards the fix, then you could say it's minimized or mitigated away its incremental contribution. So in theory, we have air quality plans where we're all going to have clean air someday. And over the course of my life, professional career, we were supposed to get to that point in 1987, then we were going to get to it in the 1990s, then we were going to get to it by 2010, and now it's 2030. Cars are getting cleaner. We're still not there yet, but we have plans to have clean air eventually. If your project's doing its fair share, then maybe it takes care of its cumulative impact. If you have impacts on endangered species, and you have a habitat conservation plan in place, which you probably don't have here, it's an Endangered Species Act plan, then compliance with that would be a way to mitigate away your incremental contribution. But lacking things like that where there's some plan to fix the problem, it's a really hard thing to come up with, what level of impact is cumulatively considerable. So it becomes a case-by-case consideration. CEQA does tell you that different cumulative impact categories might require different geographic areas to be concerned with. You don't have one area you only care about. So, for example, if you're dealing with water quality, you might look at a watershed, which might extend out quite a long ways. You're looking at air pollution, you might look at an airshed or a component of an airshed. If you're looking at groundwater, you might look at a groundwater basin or a sub-basin. So in theory, if you really do this right, you might have complicated cumulative impact analyses for different topics that have different geographic areas that they're looking at. Now, I know oak woodlands here is a big issue. There is a requirement in CEQA for a particular approach to mitigating direct impacts on oak woodlands, and these only apply to counties. But whether the loss of X number of trees or X number of acres would be cumulatively considerable would be really a function of the facts before you. I have worked in communities where they felt they had a lot of oak trees, and the loss of a relatively modest number they didn't find to be cumulatively considerable because they were just square miles and square miles and square miles of oak woodlands, or they're up against public lands where no development could occur, and those trees were part of the same ecosystem. And, the loss of the number of trees in question, according to biologists, was not a big deal. Change that fact situation. You're in the Bay Area, heavily urbanized areas. There are enclaves of oak woodlands, but those are more isolated. They're not part of a vast set of acreage. And in that context, loss of a smaller number of trees might be thought to be cumulatively considerable. So a lot of this is based on context, and there is no silver bullet. You rely heavily on your experts, but there's this built-in tension between philosophically a very low threshold makes sense, but that's utterly impractical. This has been an issue that's been dealt with a lot in the context of climate change. According to the state of California, we already are suffering from the effects of climate change in terms of reduced snowpack, rising sea levels, more wildfires. And so if you accept that premise, as you must in California because it's baked into our law, then anything we do that makes it worse, if it's already so bad, in theory would be intolerable. But we're not at that point as a society yet where we can require EIRs for every little thing that has one molecule of carbon dioxide associated with it. So it's just a hard problem. If the world's going down the tubes and we still have to keep having a functioning economy, how do you balance the need to not load up entrepreneurs with too much cost on the one hand with the need to try to deal with these environmental problems on the other? Yeah.
Your example of oak woodlands is a good one because we face it routinely in discussing this. My problem with this is maintaining oak woodlands and every oak tree for the sake of maintaining every oak tree is nonsensical, because the word healthy has to be included in the oak woodlands. I mean, otherwise you get what we have now. I mean, the last overflight on which didn't include all of California, said we have 1.6 million dead oak trees from this drought. And that's simply because they're overgrown where they are, and they're fighting for water. Some of these rules that seem to be implied just don't make any sense to me. I save an oak tree to lose all of them. I mean, that just doesn't work. And that's exactly what's happened to our forests, both on SRA and the public lands. It's crazy.
Yeah, so I guess my thought there is that every jurisdiction finds itself in a different factual context. And here you might find that oak trees are relatively plentiful and the forest is dying, and what's the point of maintaining a bunch of dead oak trees? But if I'm in the town of Alamo in Contra Costa County, and then I've got a bunch of rich neighbors who love their oak trees, and they'll sue the heck out of me if I cut any down, I may just end up, as a practical matter, treating that as a bigger impact than I would here, because the context is so different.
The context is right, but I mean, look, I love my oak trees. I don't want that misunderstood. I take care of them, but I want them healthy. Healthy is the issue. Just doing it as a blanket doesn't make sense to me.
Yeah, and I think it's a fair point. So what I would suggest there is when you are interacting with staff and consultants and trying to set a threshold for cumulative loss of oak trees, that all these factors should be accounted for. But ultimately, the threshold should reflect some scientific basis. So this should be supported by substantial evidence. So all the factors you just described could be part of the mix. Also, the adjacency of public lands. The extent to which thriving oak woodlands on national forests might be sufficient to maintain healthy ecosystems regardless of what may happen on a particular adjacent piece of property. But, the recurring theme is you've got to have evidence and reasoning supporting your outcome. But CEQA is flexible enough that it should be adapted to different fact situations. And it has that flexibility in it, but as I was saying earlier, because some of the concepts are so general in the law, reasonable minds do differ. And it's the strongly held reasonable different opinions that leads to litigation. And so you can have a totally defensible approach, as I would say, as your attorney, and yet someone feels strongly differently, and they'll sue you, and I would like to think I can predict what the judge would say, and I give you advice that it would be agreed to by a judge, but I can't guarantee that. I've been surprised a lot of times, and the longer I've had it, the more humble I am about predicting judges. You get young lawyers who say, I know what the law is. You can take it to the bank. You get older lawyers going, it's not that simple. These judges are human beings like anybody else. They're subjective. You can't predict them. They're not robots. They're not computers. So I've got 5 minutes left before we open it to comments. I want to just talk about what I think are the most important concepts remaining. Talked about alternatives. You need a range of alternatives. They're supposed to meet most of the basic objectives of the project while substantially lessening any of the significant effects. Talked about what significant effects are. There's a requirement to identify the so-called environmentally superior alternative. It doesn't mean you have to prove that. And that's an inherently subjective thing, because you have people saying, well, noise and air pollution and biology all get mixed together, and what overall is the best environmental alternative. But every alternative might involve a set of trade-offs, and CEQA doesn't rank categories of impacts and say one's more important than the other. It doesn't say biology is more important than air quality, or water quality is more important than biology. If you were to look at the totality of state and federal law, not just CEQA and NEPA, you could probably say endangered species have maybe the most protection of anything. Air and water have a lot of protection behind them, so probably those are the most important in just the grand legal landscape, but CEQA itself doesn't tell you that. So reasonable minds can differ on what is the environmentally superior alternative. So the last thing I want to talk about really is findings. So I mentioned earlier the decision-making process. You've done your draft EIR. You've sent it out for review. You now have a final EIR before you. All the comments have been responded to, and you've certified that EIR. I already talked about what that is. That's a three-part finding. You've read the document. It's legally adequate, and it reflects your independent judgment. Now you decide, we think we want to approve this project. We've heard all the testimony. We're ready to act. Well, because of the substantive policy of CEQA, thou shalt not mitigate, or thou shalt not approve projects with significant environmental effects if there are feasible mitigation measures or alternatives. You have a burden of proof that there are no feasible mitigation measures or alternatives before you approve the project as proposed. So you have to write findings describing the disposition of every significant effect on the environment identified in the EIR. And there's three findings you can make, and you can make a combination of them. Unfortunately, the language in the findings doesn't really track the language of other parts of CEQA. It's just kind of an artifact of the 70s. But basically, A1 here is you're mitigating the impact. You got a significant impact. The EIR had a bunch of mitigation measures. You're adopting them. You don't think they're infeasible. You're just adopting them, and you can get the impact down to less than significant. A2 here is there are mitigation measures in the EIR, but they're written for fish and wildlife. They're written for the regional board. They're not written for the county. So what you're required to say is, we can't adopt them because they're not written for us. But we think, and you're actually required to say, these other agencies should adopt them. You're just saying, these are for another agency acting after we do, and we think they should do it. Now, it's not binding on them, but the legislature makes you say they should do it. The third one is the one the court's going to pay the most attention to, and that's where you're rejecting something as infeasible. In the typical situation, it's not that common that mitigation measures get rejected. Mitigation measures add up to a lot of environmental protection cumulatively, but it's very common to reject alternatives. And so a lot of findings focus on the reasons why alternatives are infeasible. And as I mentioned earlier, there's at least two kinds of infeasibility. There's economic infeasibility. There's policy infeasibility, which is an undesirable outcome or a failure to meet fully the project objectives as you've articulated them. If you're going to reject the alternatives on those grounds, you need to lay it out in these findings. And because courts scrutinize those particular findings, because you're not mitigating the impacts, it's important to have good explanations and supporting substantial evidence. If you do it well, you do have legitimate policy reasons that are supported by substantial evidence, the court should uphold that. But these get litigated all the time. So this is just a practice pointer for how to do it. The important thing here is the facts. You need substantial evidence. And then I'll finish with this statement of writing considerations. We usually write the statement of writing considerations as part of the same grand document as the findings. So our findings will typically say, here's all the mitigation measures that are being adopted. Here's all the alternatives. Sometimes we're doing an alternative. Sometimes it turns out that's the choice the electeds want to make, but more commonly they reject them. Here's all the reasons why they're rejected. So we still have some significant unavoidable effects. We have concluded it's not feasible to get rid of all those significant effects. But we want to approve the project anyway. So then you articulate the reasons why. It brings jobs. It brings prosperity. It brings tax money. We need the use. There's a market demand for this. It's consistent with our general plan. Those need to be supported by evidence, but courts rarely will tell you your reasons are not good. I suppose you could come up with something really crass, like the developer gave me, I mean, you'd never do this. The developer gave me a generous campaign contribution. I figured I better approve his project. You would never put that. The court would say that's not a good reason. But if you have policy reasons here, courts should not really second guess those if they're supported by substantial evidence because of the principle of separation of powers between the branches of government. You're in the policy arena. You're a legislative body. This is what you've been elected to do. You represent the people. And if this is the outcome you want as a legislative body, courts shouldn't second guess that. They're not elected to be policymakers. As long as you've dotted your I's and crossed your T's, supported your decision with evidence, you should be good. So it's about quarter of. I feel comfortable stopping here, and I hand it over to the chair.
Awesome. Thank you very much. What I'd like to do now is we'll take up to about 5 minutes for the board. I'd like to leave 10 minutes for the public if we can. And we are scheduled to close on the hour, so I'll try and do that. And the board have anything, or you want to ask, or you want to hear from the public?
One question. I was responsible for the break going a little bit longer. I asked kind of a side question, and it has to do with approving a document that has been vetted. In a sense, it's been sent out to the agencies, but an agency hasn't responded. Are we at a risk to approving that document, knowing that there is lacking a comment from the regulatory agency?
You're not necessarily at risk, provided that they had the opportunity to comment. They were given whatever legal notice they were entitled to. If they choose not to comment, there's actually case law that says that, like the dog in Sherlock Holmes that tellingly failed to bark, you can treat their silence as a lack of objection. On the other hand, if you forgot to notice them and they never heard about the project, you could lose in court for inadequate notice. And under that fact situation, you can't really draw any conclusions from their silence because it's your fault that they didn't hear about the project.
Okay, thank you.
So what sometimes happens, though, is, and this happens more with the federal agencies in my experience, they don't comment on it on the EIR when they're supposed to, and then maybe they send you in a letter at the last minute saying your EIR is no good. That's very frustrating because why did they wait to the bitter end? But you can't control what they do.
Okay, thank you.
But that's still part of the public record.
Still part of the public record, yeah.
Yep. Supervisor Handbell.
Yeah, well, first of all, I want to thank you for being here.
My pleasure.
I don't know that I'd compare you with Paul McCartney. You didn't get 20,000 people in here. But on the other hand,
I think she meant it as a compliment.
I did mean it.
I got a lot more gray hair than at least he's willing to show in public.
I don't think he'd have done well with this subject, by the way. Anyway, but I thank you because you did a lot to educate me, particularly, and I need a lot of education on this subject, clearly. But in that last question that Supervisor Gray asked, how does that work with federal agencies as opposed to state agencies? I mean, you send them the notice, you send them things, and they operate in their usual pompous fashion and aloof to things and just don't respond. Yet they still have jurisdiction.
It is a common frustration. If you talk to people in those agencies, they say they're overstretched, they don't have the resources. Some people are skeptical of those claims. It is a problem because if and when they do finally chime in, and maybe the day of the hearing on the merits, it's part of the record. And if you have a litigant, they can use that letter from the U.S. Fish and Wildlife Service against you. It's most damaging in the context of a negative declaration. You might have a clean record, no one's saying significant effect. There's no fair argument, and then you get this letter from Fish and Wildlife saying you're going to do some terrible thing to some animal.
I always think the Corps of Engineers is who I was thinking.
Yeah, I mean, so the litigant can use that. Where they do have jurisdiction, and you need to work with them for the project to be successful. Either you just have to put up with that, or maybe you just have to go out of your way to ring their doorbell multiple times to get their attention. It's probably in your interest to try to get their attention early rather than late. If they do have the permit that you need to have the project work, and they're an absolute brick wall if you can't get past them, I think it's in your light and self-interest to try to get their attention early. Even if they don't seem to want to respond, just keep after them.
Okay. Supervisor Brennan, you got anything?
No, I just want to thank you for the discussion on cumulative impacts. We talked during the break.
Yeah, I wish I had a silver bullet for you.
Yeah, clear as muddy water. Thanks.
Okay, I'm going to go ahead and open it up to the public for any questions or comments. We will ask you to come to the podium and make those. And I would ask you, since we have quite a few people here, to, unlike politicians, try and be brief. And so come on up. Anybody?
announce myself?
You're a member of the public, not required.
Awesome. Hi. Speaking in a position of ignorance on this, being building inspection staff, contents of EIR specifically, baseline for environmental analysis. You mentioned it is at the setting at the time of the NOP. Is it appropriate in some cases to move that to a position that would most likely be a time where this area could be affected by an impact? For instance, let's say this could be a migratory path and stopover for waterfowl, but the NOP starts at the wrong time. It's off migration. This could lead to an argument or even a litigation because they'll question whether or not it's even used as a stopover, where if you pushed it to that point where it's during migration, the analysis could show definitively. Is that an appropriate tactic?
I think you could be required to acknowledge that it has value for migratory birds. So the subject of baseline turns out to be enormously complicated, so I didn't do justice to it due to lack of time. But since you asked the question, I'll get into some of the nuances. The default position is time of the NOP, but the courts have recognized that that could be misleading. So if you look out your car window in the middle of a drought and you don't account for the fluctuations in hydrology of the state, you might have an artificially low sense of how much rainfall is going to occur over the next 50 years. On the other hand, if you look out the window, there's a flood. You might conclude there's a lot more water than you can really depend on because it's swirling around your feet on that particular day. So in that situation, you can define the existing conditions as the continuation of a pattern that the past has shown you. So it's not necessarily the day of the NOP, but the general conditions. So if you have over the course of a year certain phenomena, I think you take that into account.
Okay.
There's been case law dealing with industries where they have fluctuations in levels of activity. So if I am a surface mining operation and I want to extend a conditional use permit and there's a recession right now and I'm not doing any work, there's an artificially low amount of trucking happening right now. And so you don't want to treat that as a baseline because back when the economy was booming, there were trucks everywhere. So you can see fluctuating baseline. You can look back and try to ascertain an average and call that
not
your
necessarily
existing.
starting at a date, but if you start this analysis, you recognize the seasonal pattern in your report, and that ends any potential arguments.
Right, and so what you want to do is really get it right. And so if you're using the snapshot at the car window as a way to minimize effects, because it just happened to be a day where it was a low level of activity or high level, whatever was advantageous to minimizing the effects, then the court might say that's misleading.
Right.
So with water projects, it's all the time they do this. They have an 82-year hydrological record. They assume it'll be the same going forward, which is probably not true anymore, but that's all we have. And so it's like this. So sometimes it rains a lot, sometimes it doesn't, but it seems, based in the past, that the droughts are followed by a lot of water. So in California, we always seem to be dodging floods or droughts. The assumption is that'll continue. Like in the facts you just discussed, if the birds come once a year, that's going to continue. Another thing you can do is you can look beyond project approval if there's a situation that will occur on opening day. And the California Supreme Court has talked about a situation where at the time of the NOP, someone is building a high-rise right next to the project site. But by the time this project would open, that high-rise is going to be in place. So for your visual impacts, you're going to assume that's in place because it's so foreseeable, even though it's not there now. So there is some flexibility. But, the fundamental thing is to try to get an accurate and realistic analysis.
Okay, thank you.
You're welcome.
Thanks, Doug. Yes, sir.
Good afternoon. Thank you for coming.
You're welcome.
A question, you were talking about a mitigated negative deck before, and if there's any changes in the final approval process, it has to be recirculated. Is that if the Board of Supervisors makes any modifications to a mitigated negative deck in the final approval as far as some of the conditions of approval, or how does that apply?
So, okay, good questions. Let me just give you a little more of a nuanced discussion of that. If you're in a situation where the county council is telling you there's clearly a fair argument that this project may have a significant effect based on public input, and you were to add a mitigation measure, it could be the Planning Commission or the board, but it's after the public review period, but for that new mitigation measure, you'd have to do an EIR. Under that fact situation, you have to go back and run it through again. Now, there is the ability to substitute an equally or more protective mitigation measure for one that's in the mitigated neg deck. And if there's no loss of environmental protection, even if it's a more efficient way to go, you don't have to recirculate. But that's because you're swapping one for another with no loss of protection.
Okay.
And even in that situation, there's a mandatory public hearing on that as a check to make sure that it truly is equally strong or stronger.
Okay. How does it relate to if it might just be a condition of approval and it's not necessarily related to a specific mitigation for that program?
So carte blanche to play around with conditions of approval as long as they don't rise to the level of being mitigation measures, but for which you otherwise would have a significant effect. So in a typical project, you've got some mitigation measures, but you've got a much larger number of conditions of approval. Those are being imposed pursuant to the county's police power. They may not involve environmental issues, or they may involve environmental issues that don't rise to the level of dealing with significant effects. And so the county has great flexibility to tweak those. The only ones that are problematic are ones that you're trying to add as a way to avoid an EIR.
Okay.
And without them, or one measure, you'd otherwise be looking at an EIR.
Okay.
So it doesn't apply to the vast majority of conditions of approval, like I need some sidewalk frontage from you, I need to help you paint a stripe on the pavement for a turn lane into your business, that sort of thing.
Okay. Thank you.
You're welcome.
Thank you. Yes, ma'am.
Sharon Maravich, Tuolumne Heritage Committee. This is on categorical exemptions and exceptions to categorical exemptions. On categorical exemptions, number 31 is historical resource restoration or rehabilitation. And then on exceptions to categorical exemptions is historical resources. What's the difference? Is the assumption that under 31 there's going to be something positive happening to the resource, whereas under the exceptions it's kind of a negative thing?
Short answer, that's right.
Is that what it is?
So, as I think you know, but maybe not everybody in the room knows, and I didn't have time to talk about, CEQA has special protections for historical resources. It's a term of art. They get a higher level of protection than a lot of other resources. Defined term of art, if something is listed in the California Register of Historical Resources or is determined by the local agency to be eligible for listing, or if it's a landmark in a local ordinance or otherwise has special status as a historical resource or under a local ordinance, or it meets certain criteria set out in the Public Resources Code, like it's an important example of its type of structure, or it's associated with an important person, like George Washington slept here, which doesn't happen in California, then it's entitled to be called an historical resource. And under CEQA, if you have a project that would cause a substantial adverse change in a historical resource, that is a significant effect on the environment. That's defined as a significant effect on the environment. So if you have a discretionary demolition permit and someone wants to knock down a historical resource, you have to do an EIR for that.
Okay, isn't it?
And that's why you can't do it at Cat X. Now, the exemption you talked about is rehabilitating something pursuant to standards the Secretary of Interior has promulgated that are intended to maintain the historical character. So you can have an old historic structure which is falling apart, but you use these special rules to try to maintain the historical quality of it. And so you refurbish it in a sensitive way that's consistent with its original historic character. That's what the categorical exemption for. It's correct. That's a good thing. You're making the structure better as opposed to knocking it down and getting rid of it. And if you ever do that, you can't do the categorical exemption because of the fact that becomes a significant effect. And you need to do an EIR for that.
I thought that in about 1994, Governor Wilson signed a CEQA change that said a thing can be considered historical if it's over 50 years old. Well, it can be considered historical. It doesn't have to be on a register. It doesn't have to have been evaluated. It doesn't have to be on an inventory. Just the fact that it's 50 years old is, in fact, it can be considered a historical resource because public agencies were saying, oh, it's not on a list, or it's never been evaluated, or anything like that. And I just was wondering if that section is still in there.
Yes. So what the courts have done with that is they've, this is 21084.1, I thought. In any event, so the courts have said there's categories of mandatory historical resources
Yes.
and then some that are discretionary.
Yes.
And so there's this, it's listed, it's eligible for listing, it's local or other, and then
Other.
there are criteria that you apply
Okay.
under this other. And there's a sense that anything 50 years old may be historical. I think that's one factor. It's not a per se thing. That,
No,
if your
that's
house
true.
is 51 years old, now you can't touch it. It's a desecration. It's more of an indication that it could be historical. But I think the totality of these criteria need to be brought to bear. But the law has not been changed. It's just been interpreted a little bit.
Yes, ma'am.
It's 12 o'clock, though. Do you want to cut me off?
I would never do that.
Okay, thank you. I want to thank you so much for
You're welcome.
coming up. I was real excited when I found out this morning at 6 o'clock that there was going to be an environmental attorney here. And I was expecting someone else who had gone to Oregon. So I have my ducks and my green and gold socks.
I appreciate that.
But I don't think you
I'm
went
not
to
a
Oregon.
Oregon
I won't
guy,
cut
but
you
I
off, but can
appreciate
you get
the
to the point?
Okay. So anyway, I'm very excited that you were here. Thank you very much. I'm glad that someone was able here to record this so that other people could see this. I thought you had a lot of information to add. This is, a big topic of controversy here. However, I am upset at the agenda. This was published last week. I saw it when the other agenda came out, and I consider this a substantial Brown Act violation because all this says is presentation and workshop on the California Environmental Quality Act. And nowhere on here did it say that there was going to be an attorney, that there was going to be a rock star of your caliber here. And I felt this was deceitful and manipulative to the public because if anyone had known that you were going to be here, there would be more in the public than just me. So whoever did this agenda, I say shame on you. Thank you.
Thank you. Okay, with that happy note, I'll go ahead and adjourn this special session of the Tuolumne County Board of Supervisors.